We are live again, so welcome back from the lunch break. We appreciate everyone for hanging in with us. We're going to go ahead and get started with our 11 a.m. item on the agenda, which is the COVID immunity legislation that we worked on in the day that we were doing COVID-only related topics. A working group was created out of that, as well as the committee during that time adopted a bill draft from Representative Stith concerning COVID immunity that he presented at our last meeting. I'm the first on the agenda item for a working group update. The working group was, the productivity there was less than desirable as a result of kind of unclear terms of what was requested of us as far as inconsistent communications from legislative leadership. As you probably know, the Travel Committee took up its own COVID-related immunity bill. And members of our working group had been working with the Travel Committee. And of course, Senator Anselmi Dalton also serves on that committee as well. So a lot of duplicated efforts, duplicated time, multiple concepts going around, and multiple different initiatives also being presented. So really in an effort to avoid additional confusion, both to the public, to the stakeholders, to the legislature, an additional bill draft was not created or suggested necessarily from that working group. That working group instead chose recently to just have LSO provide kind of a summation to this committee of all of the different work that's being conducted across the legislature and some of the concepts associated with those different bill drafts and laws currently on the books. And so that really is the consensus, I think, and the best path forward instead of further complicating and wasting efforts. There also was a challenge associated of when and if a special session were to occur, and recognizing that ever moving target, I think, as we've all been aware, has been a bit challenging as well. So that's my working group update. I don't think many members of this committee participated much or has anything else to participate. So, but if you'd like to add anything, I think Representative Pelkey was online maybe once, or anyone else, but Representative Ponnell showed up. Any comments from Representative Ponnell?
Thank you, Madam Chair. No, I don't have anything further to say. I think you explained it, and it's an issue that we probably need to deal with, but I have nothing to say.
Great. So, Mr. Fuller, Mr. Hopkinson, I don't know if you're back yet and ready to go, but if so, let's go ahead and do the introduction of bill drafts.
Yep, and Chairman Othercott, members of the committee, I suppose, you know, I sent out some information late or maybe early, I believe it was early this week. I sent a separate document for the committee to consider. And I think with the committee's pleasure, I would just like to highlight what the current law is now, give a broad overview of the bill draft this committee requested, which is 21 LSO 108. And then also give a kind of a brief summation of 21 LSO 33, which is the draft that the Joint Travel Committee voted to sponsor last month, before wrapping up with just some potential areas for the committee to consider, you know, should it take up this topic, you know, in more depth. The one thing I would just make clear at the outset is that, you know, LSO has no opinion on the merits or policy of any of these bill drafts. I will highlight a couple of differences that the committee would want to account for if it considers this topic. So with that in mind, in the May, so before the May 2020 special session, immunity from liability during a public health emergency existed for any healthcare provider or other person who in good faith followed the instructions of the state health officer in responding to the public health emergency. Immunity was not available if the conduct was grossly negligent or willful or wanton misconduct. And it had to be during, the actions had to be during a public health emergency that was declared. In the May 2020 special session, the legislature changed that statute to also include a business entity covered under the immunity, and that immunity was available if that healthcare provider or other person or business entity in good faith followed the instructions of the state or a county, city, town health officer, or who acts in good faith in responding to the public health emergency, would be immune from liability from complying with the instructions, or if they acted in good faith. Moving on to this committee's bill draft that was requested, 21 LSO 108. This bill draft would provide immunity during a public health emergency to any person or entity who follows in good faith the instructions of a health officer, whether state or local, or who acts in good faith in responding to the public health emergency. So similarly to the current law, the immunity would apply only during a public health emergency. You would have to follow in good faith the instructions of a health officer or act in good faith in responding. The immunity still would not be available if it was gross negligence or willful or wanton misconduct. And 108 clarifies that the immunity would apply only to claims alleging actions or omissions that cause exposure to or contraction of the disease for which the public health emergency is declared, and to claims that arise from those actions and omissions that occurred during the emergency. 108 also specifies that the changes to immunity would be prospective. So it would only apply to actions or omissions occurring on or after the effective date of that bill draft. And with that, I'm happy to answer any questions, or if the committee wishes, I can go into specific detail for that bill draft.
Any questions for Mr. Fuller at this time? All right, please proceed, Representative Pannell.
Thank you, Madam Chair. Just one question. You know, we had some, and I'm not sure if I was trying to read this in there, but we had discussion on, you know, to prevent on this, the businesses and so forth, that they would have to hire an attorney. Is in this bill, because I'm not an attorney to read it, but in this bill, is there some sort of a hearing or something set instead of going on to a jury, but immediately can be set to where it can be dismissed because it's frivolous? Does this bill address that?
Chairman Othercott, Representative Pannell, this bill does not. So it would be incumbent on the business or the entity who is being sued to assert, whether at you know, a preliminary stage, motion to dismiss, or summary judgment, that they are entitled to the immunity that is provided in that section.
Further questions for Mr. Fuller? All right, seeing none. Mr. Fuller, do you want to continue?
Yep, and then Chairman Othercott, members of the committee, I'll move on now briefly to 21 LSO 33. This is the bill draft that Joint Travel, Recreation, Wildlife voted to sponsor. There are many similarities to the language in this bill draft compared to 108, but I would highlight a couple of differences. First, any complaint that would be filed that alleges acts or omissions that caused exposure to or contracting a disease, that complaint would have to state with particularity the acts or omissions constituting the basis of the civil action. So that would be a higher standard that would have to be met in the complaint that is filed before, you know, kind of the doors would fling open to move ahead in the case. Second, there's a provision in draft 33 that requires any person who is alleging acts or omissions that cause exposure or contracting a disease to be proved by clear and convincing evidence. And what this means, how the Wyoming Supreme Court has interpreted this, is that it's the kind of proof that would persuade a trier of fact that that the truth of that contention or that argument is highly probable. So that is different. That is a different standard than the preponderance of the evidence, where you know, the act or omission alleged was more likely than not to have happened. Further, this bill draft also states that the immunity, so in addition to the good faith language, this draft states that the immunity is available to any person or entity whose alleged act or omission was in substantial compliance or was consistent with any federal, state, city, or county statute, regulation, order, ordinance, or public health guidance that's related to the disease for which the public health emergency was declared. And then finally, the final notable difference in this bill draft is that if it's enacted, it would apply to all civil actions occurring on or after March 13th, 2020, the date for which the public health emergency was declared. In the document I sent as well, I summarized some actions that other states have taken, including on page 6 of that document, a fairly detailed description of what Iowa has done with enacting a law for immunity during a public health emergency. That was a legislation that the working group had identified, and took a look at during its considerations. And then finally, to wrap up, some things the committee may or may not want to look at, depending on where the committee wants to go with this topic, is just a question of the scope of the immunity that's provided, the level of action necessary for a person or business to claim that, whether it's simply acting in good faith, whether it's substantially complying with a public health order, the burden of proof for establishing those claims, the standard required for filing a complaint, and what must be in that complaint to proceed. And then finally, whether the immunity that's conferred in a bill draft should be conferred prospectively or retroactively. And here I would just note that if, in terms of retroactivity, the United States Supreme Court has stated that that concept is not favored in the law. There is a deeply rooted presumption against retroactivity that the Supreme Court has held. And really the question is, what happens to, how should a cause of action be treated that is already accrued? The United States Supreme Court has said that under the Due Process Clause, once a cause of action has accrued, it is a species of property right that is protected under that clause. And so the question would be, if how would those claims be handled, and what legal challenges would arise, if the standards for proof or pleading are changed after, after a cause of action has accrued. With that, I'm happy to answer any questions.
Thank you, Mr. Fuller. I think that memo was just really, really helpful for us to get our arms around all of the moving parts on this topic. Representative Jennings.
Thank you, Madam Chairman. I'm just curious, maybe this is Mr. Fuller or maybe the other lawyers on the committee. So we're 4 or 5 months into this, and there's been lots of cases. Are there cases pending now? Do you guys know of how many cases we're looking at across the state? Is it too soon to know whether there's going to be legal actions taken? I'm just curious.
I could just answer that. I think Mr. Fuller may or may not know. I'm not aware of any cases in the state concerning this issue. Whether or not it's too soon, cases certainly could have been filed by now as a result of people contracting the virus and or dying from the virus. And so they could have done that at the time of contraction or at the time of death, of course. And I'm not aware of any case being filed. Now, that's not to say that they couldn't move forward and file. The facts and circumstances associated with their allegation would depend on when their statute of limitations would run. But generally speaking, Wyoming has a very short statute of limitations for wrongful death. And assuming that's the most likely cause of action would be associated with the death as opposed to just getting the virus, and that's 2 years. So 2 years from the time of the death, the individual would have the ability to bring suit, or their family would have the individual to bring suit. And so there's already a strong kind of limitation on liability there with that shortened statute of limitations deadline. But that's the issue. Representative Washit.
Thank you, Madam Chair. It does seem at least potentially problematic if we were to change the legal standards, if you will, with regards to this topic retroactively, when we've had law in place up until this point from our May meeting. Now we change it again in January, presumably making that retroactive. Not being a lawyer, does that complicate things?
Senator Anselmi Dalton.
Thank you, Madam Chair. I think it's a bad idea to go retroactively. It's always a bad idea in the law. The Supreme Court has said it's a bad idea. You're not only changing, the time frame, you're changing in the bill, they're changing the level of proof. So we had that LLC bill a few years back that did the same thing. And I think it's a bad idea but there haven't been any lawsuits. I think there's maybe one about a property dispute, but there haven't been any yet that I've seen on that COVID lawsuit tracker yet that I think Senator Chairman Nethercott said us. So I think that's something that we should think about as we go forward, even if we use a TRW bill.
Further questions from Mr. Fuller on the topic? So I think as we hear public comment on it, and there's going to be a significant amount from a number of competing interests, those that drafted the travel committee's bill, those that are nervous about liability, those that are concerned about rights and access to the courthouse. I think it would be smart for the committee to keep in mind these options that LSO has provided for us based on all of the work that's been done, and determine those priorities for what any amendments need to be made to the current bill draft that this committee chose to move forward, or whether or not we want to kind of defer the actions to the travel committee's bill and just kind of walk away from this topic, or if something further should be done. But those are, I think, the options that we should be mindful of as we hear public comment on the topic. So with that, we welcome public comment. And I think there's a number of folks here that have been very patient with us. And I guess we can probably go ahead as they all enter the room. I know we have Ms. Delancey from the Business Alliance, who is, I think, joined with Attorney Brad Cave. If they want to start with that public comment, they'd be more than welcome.
Thank you, Madam Chairman. I'm not sure if I see Mr. Cave on the screen yet.
He is present, yep.
Wonderful, great. I'm going to go ahead, Madam Chairman. My name is Cindy Delancey. I am the president of the Wyoming Business Alliance. I deeply appreciate the ability to be part of the working group. Unfortunately, I have not been able to see the memo that was provided to you all as a member of the working group. It's something that would be helpful and instructive to me, but just wanted to kind of pick up our perspective on this situation. By way of recap, Mr. Fuller did a nice job outlining the work of this special session. By way of reminder, this topic was assigned to Judiciary. It has also been picked up by TRW at the request of the outfitters. That committee worked this issue with significant input from the business community, came up with the version that Mr. Fuller walked you through as well. And now after your last meeting, this bill was amended. Basically, the number one concern for the Business Alliance and the business community in this bill is you basically are opening the floodgates if you pass your version. And specifically, I'm going to draw your attention to page 5, line 9 through 12. This is a significant detail that maybe was somewhat, maybe not thoroughly presented in the way, that the implications as far as this language. 9 says this immunity shall not apply. So basically the immunity is gone to civil actions alleging acts or omissions constituting gross negligence or willful and wanton conduct. If you use this language in this bill, you basically have lowered the threshold that anybody can allege anything. And if those allegations contain the words gross negligence or willful and wanton misconduct, there is no the liability protection just vanishes, poof, goes away. So that is an even lower threshold than what was done during the special session. So this bill in essence takes us backwards, not forwards, as far as offering protections for businesses right now. Protection for businesses, particularly our small businesses in Wyoming, is what is desperately needed. Our economy is at a time that we are more fragile than ever. We're trying desperately to keep our doors open. And this looming threat of a wrongful death lawsuit that could cause financial ruin, reputational harm, all the stress that goes with being forced into a posture of litigation is why the business community really prefers the TRW version of the bill, specifically outlining the 3 topics of distinction that Mr. Fuller walked you through. The first one being what I just said. There's a higher threshold to plead with particularity in the TRW bill. And what that means for the non-lawyers is you basically have to tell the court and the defendant what specific, in the TRW version, what specific actions that you as the plaintiff believe caused your harm or injury, as opposed to the judiciary version where you can just say those magic words and you've tied the court's hands to eliminate any chance of applying immunity in the process. So that's the first distinction and the first reason why the business community prefers the TRW version. The second one is the evidentiary standard. Right now, in the judiciary version, the standard applicable would be preponderance of the evidence. As Mr. Fuller said, we have 3 standards in the courts for the non-lawyers. Preponderance of the evidence being the lowest standard, and beyond a reasonable doubt being the highest standard, which is applicable in criminal matters. TRW's version kind of takes that a little bit, ratchets it up and gives us that middle standard where the court would be able to use that as a procedural mechanism to allow the cases that truly allege with supporting documentation or facts or statements as to why there's a harm to move forward. And the court would be able to ferret out those that are frivolous and could potentially be just, encouraging litigation, frivolous claims to go away. And that's not available to the court in the judiciary version. What the concern is there and why we feel that procedural mechanism is needed for the business community, for the court to be able to apply, is the current words in the judiciary bill, good faith, become a factual question that only a jury can answer. And to get that matter to the jury, the business would have to defend itself all the way through a long drawn out process to get that question to the jury to determine whether or not the conduct by the alleged or purported bad actor met that good faith standard or not. Good faith is generally a term that's used in a more of a transactional or business context, not necessarily a health context. And that's where that language substantial compliance comes up in the TRW bill, also giving a preferential desire for the business community to avoid getting into that factual determination of a jury question and allowing a judge to ferret out those cases that shouldn't go forward and allow those cases that should. The other, as related to retroactivity, that's fine. We can fix that in the TRW bill if there's concerns about that. The judiciary bill kind of does the same thing. And in fact, it's not a retroactive action. It actually creates a gap. When you look at page 8, lines 18 through 21, there would be a gap essentially compared to the work that was done during the special session, as opposed to, if this becomes applicable and becomes law. So it's kind of, 6 one, half dozen the other. There's work to be done as far as getting the timing right. It is always challenging, especially for lawyers, to figure out that right time to file. I know that Representative Washut brought up the issue of, do we have any cases? And the chairman is absolutely right. We won't know for 2 years. People don't just go run into the courthouse once they've lost a loved one in a wrongful death situation. We'll know the outcome of this in 2 years. And that's where the business community is just asking you, as our lawmakers, to please help us navigate these challenging times more than ever. And this is really a protection that we feel is needed right now to help us as we work on reigniting our economy, to be fearful of a lawsuit around every corner when we're trying to do the right thing as businesses. We've done the right thing from the business perspective by taking care of our employees and bringing them under the workers' compensation statutes. This is really the business protection that we feel is necessary. This is something also in closing that's not unique to Wyoming. 26 other states have taken steps with their state legislature to try to enact this type of protection that we're asking for. So that is a quick outline. I have Mr. Cave with me in case I missed anything or any points that maybe he might want to add in conclusion, Madam Chairman, as far as really kind of providing justification. I know this has been a very long meeting. When I started lobbying 15 years ago, I was always told that the Judiciary Committee was the too hard committee, meaning any topic that was too hard got thrown in the Judiciary bucket, because this is the A team. And after listening to some of the incredibly challenging topics that you've been grappling the past few days, but from DUI to Title 25 to electronic filings, and now this is another one of those topics that is extremely challenging. We're really splitting hairs in some of the language that's used in these statutes, but we're asking, this is a high priority for the business community and specifically for my members. And to get this right, to protect us from frivolous lawsuits that would cause financial ruin is really why we're asking for that you consider TRW committee version 3. So with that, Madam Chairman, thank you.
Thank you, Ms. Delancey. Couple of questions. Is Wyoming included in those 26 states for the legislation we did pass in the special session?
Madam Chairman, not on that list that I was provided from let me see, where's the source of this? This is the insurance, APCI insurance group is where that list came from. So no, so perhaps maybe 27 of the states have taken action on this topic.
All right. Mr. Kay, would you like to add anything? You're still on mute.
Thank you, Madam Chairman. I would briefly like to add a few thoughts, and thank you for allowing me to participate on behalf of the Business Alliance and the working group as well. Ms. Delancey laid out some of the key differences. I want to address retroactivity because it's obviously a concern of many of the committee members.
Mr. I'm sorry to interrupt you. Introduce yourself for the committee, just so we have the record.
My apologies. I'm Brad Cave. I'm a lawyer at Holland and Hart here in Cheyenne, and I've been asked by the Business Alliance to assist it with this issue, and I'm here on behalf of the Business Alliance. So, with respect to retroactivity, the earlier comments are right in the sense that the Wyoming Supreme Court and the U.S. Supreme Court have said that retroactivity of statutes is not favored. The Wyoming Supreme Court has permitted retroactivity when the legislature has spelled it out in the legislation. And so it's not as though there's a bar against the retroactivity of statutes. The committee has discussed the fact that at this point, we're not aware of any lawsuits being filed in Wyoming. So I suggest to the committee that including the TRW retroactivity language is not as problematic as it may seem. If a lawsuit's filed before this bill becomes effective, the litigants, the plaintiff will have an argument that the bill should not be applied retroactively, A trial judge can make that determination, and then that can be reviewed by the Wyoming Supreme Court. And the issue of retroactivity can be decided by the court based on the language in the TRW bill. So I don't see that that's not an overwhelming obstacle to the retroactivity issue. Yes, in the event a lawsuit's filed before the bill became effective, it would create a legal issue, but that's what courts do every day. Returning to what I think is the more important issue that Ms. Delancey raised, that I think I can add some more perspective to, is how the Judiciary Committee bill will play out, I believe, in litigation. First of all, our statute of limitations, wrongful death, 2 years, as was mentioned before. A negligence case in Wyoming is a 4-year statute of limitations. So we could have claims of negligent infection of coronavirus for up to 4 years from the date of the claim accrued. So we do have a long period of time to think about here. If a lawsuit's filed, the whole point of the TRW bill, as I understand it, is to allow that lawsuit to be tested early, so that this really does provide immunity to businesses and to people and entities in the state, if in fact the lawsuit can't measure up to the requirements of the statute and the requirements of the law generally. I'm afraid the Judiciary Committee bill doesn't do that. By saying, by using the phrase that it does not apply to any action alleging gross negligence or willful and wanton misconduct, all a complaint will have to do to get out from under the Judiciary Committee bill is use those words, gross negligence or willful and wanton misconduct. I can tell you I've been litigating in Wyoming for 30 years. Almost every negligence case that you see includes allegations of gross negligence or willful and wanton misconduct. I've defended individuals who have been sued for co-employee liability, where the standard is willful and wanton misconduct. And we've not been able to get out of those cases based solely on the inclusion of those words in the complaint until late in the complaint, after they've spent years, or at least several months, defending themselves. So there's a very significant concern that the Judiciary Committee bill does not create anything approaching immunity or protection against lawsuits, nor does it create any methodology to test these cases at an early stage where a party should be able to get out of a case promptly and efficiently. That is what the TRW bill, I believe, is drafted to do. I think it will effectively do so. And so with that, I appreciate the committee's time, and I'm happy to try to answer any questions.
Thank you, Mr. Cave. And for clarity, you primarily drafted that bill, correct?
I provided input on drafting that bill to the LSO. These were certainly ideas and language that I provided to LSO.
Representative Stith.
Madam Chairman, this question directed to Ms. Delancey and Mr. Cave. Just so I understand your position, I take it it's not your position that a person should have immunity if they willfully and intentionally expose someone to COVID-19 that causes their death, right? I mean, that's not your position. And if I'm correct in that, then would it be a fix to the Judiciary Committee bill on page 5 to just delete the words civil actions alleging and say that the immunity does not apply to acts of gross negligence or willful and wanton misconduct?
Madam Chairman, Representative Stith, you're 100% correct. That is certainly not, the business community is not asking for a free pass for, reaching a standard of care to the public. That's certainly not what we're after. I appreciate your thoughts and suggestions. However, I don't think that goes far enough. It would certainly be better than what the language is there now, but it doesn't resolve the issue of having to litigate and creating that jury question to try to determine what good faith conduct is. The words in the TRW bill are substantial compliance. Other states have used language. Nevada uses controlling health standards. That good faith is such a subjective term that the only way for the court to reach resolution for the defendant is to be able to have a jury decide whether their conduct rose to that level of good faith or not. So I appreciate your thoughts on trying to resolve the removing the word alleging to kind of, tighten things up, but it also doesn't resolve the issue of having to get through the end of the process and have to defend yourself through litigation to determine as to whether or not your conduct rose to the level of good faith. Mr. Cave might have some thoughts on that as well. Thank you.
No further thoughts.
Any further follow-up, Representative Stith?
Thank you, Madam Chairman. Yes. So the good faith language in proposed bill 108 is taken from existing statute 35-4-114, which was adopted in 2003. Are you aware of any problems that have been encountered in the 17 years that we've had this good faith standard under 35-4-114 that makes it unworkable?
Mr. Cave?
Thank you, Madam Chairman. Representative Stith, I'm not aware of any litigation that has even used 35-4-114. And so there's certainly not been a Wyoming Supreme Court case interpreting it or applying it to any particular case.
All right, any further follow-up, Representative Stith?
No.
All right, with that, we'll turn to additional public comment. I think we have Ms. Shaner, I think, and Mr. Aronowitz. Ms. Shaner, Mr. Aronowitz, if you'd like to go live, that'd be helpful. Thank you. Good to see your faces. If you'd introduce yourselves to the committee, and we'd be glad to hear from you.
Madam Chairman, this is Marcia Shaner with the Wyoming Trial Lawyers Association. Mr. Aronowitz will be making most of our comments today. I just wanted to thank the committee for all the time and effort that you have spent on this issue, for putting together a working group, and for including a diverse group of participants in that group. And before I turn it over to Mr. Aronowitz, I would just like to remind the committee that this bill and this issue applies to consumers too, and that our efforts should be in consideration of those folks who are supporting our small businesses reopening and want to know that the business community is doing their best to protect them. And so with that, I will just again say thank you and turn it over to Mr. Aronowitz.
Madam Chairman, members of the committee, my name is Mark Aronowitz. I'm a practicing attorney and speaking today on behalf of the Wyoming Trial Lawyers Association. I will try to be as brief as possible. I know it's been a long day. My opinion on this issue and these different bills is that your work is done. Immunity is the law. It's been the law since May. It applies during a public health emergency, which we are in. It applies to business entities. It applies to persons. It applies to healthcare providers. It's broad. It does have an exception for gross negligence or willful and wanton misconduct, as it should. That is the law today. But as the trial lawyer in the room, who people are very concerned with the cases that we might file, let me give you a little perspective on these cases. I have to prove some very difficult things if I am representing a plaintiff who has contracted the coronavirus. I have to prove causation, that the healthcare provider, the business entity, the person caused my client to contract this disease, that they are responsible for that. This virus has a 5 to 14 day latency period. I don't know how on earth you actually prove that for most people. Like if I go to the local brew pub on a Monday and I'm diagnosed the following Thursday to show I got it during the 1 hour I was in that restaurant, that is a nearly impossible burden to prove. Next is damages. most people, fortunately, will recover from this virus. We've got, I think, 3,300 cases in the state so far. Something like 2,800 people have already recovered. Those people do not have permanent life-altering damages, hopefully. Like, the damages part of their claim is small. If they got tested, they went home, they got better, and they returned to a normal life. Death cases could be different if it's somebody in a nursing home who has no chance to be out there in the world. And, if something has happened there where they were unfortunately exposed. But even then, all the healthcare provider has to do is act in good faith, follow the rules, and then you have the actual law of immunity. And that is a nearly impossible burden to overcome if you want to represent those folks. And again, that is the law today. And that is probably why, in addition to the causation and the damages, where Wyoming has 0 known lawsuits relating to this virus, with over 3,000 positive cases so far. So I get it that the business community wants absolute certainty. And they say they need these changes, but they don't need these changes. They want these changes. You don't need these changes if there are 0 lawsuits that are flooding the courts. So I don't think you mess with pleading standards or evidentiary standards or be telling the courts what to do. I don't think we have a problem here in this state. I think you've spent a tremendous amount of time on this issue. Immunity is the law today, August 21st. And I don't know, I just think it's a done issue.
Thank you, Mr. Aronowitz. Ms. Shaner, do you have follow-up?
Madam Chairman, I just had meant to tell you that the statistics that I have do say that 27 states, including Wyoming, have passed immunity statutes or have executive orders in place. 12 of those have executive orders granting immunity. So Wyoming is listed depending on where you go, and there are 27 states in the statistics that I have.
Thank you, Ms. Shaner. Mr. Aronowitz, I heard one of the primary concerns, and interested to hear your thoughts about this, which is the current law requires a good faith showing of being reasonable in response to the pandemic. It doesn't even require you to be in good faith with the health orders. It just says, or good faith behavior, which is, I think, a pretty low bar. But the point of, I think, the business community is that that's too difficult to demonstrate to the court, and they would prefer that it be substantial compliance as the standard, kind of as the fact inquiry. And so what are your thoughts about, so this is how it plays out in my mind. So somebody files a complaint for wrongful death for contracting COVID against a business entity. The business entity files a motion to dismiss or a motion for summary judgment and claims that they have been acting in good faith, and ask for the court to make that decision. Is that something that the court can decide, a good faith determination, or is that something that only a jury can decide? And as compared to that, if I'm filing that motion to dismiss and I say, hey, I've been in substantial compliance with the court's orders, just kind of help us understand the distinguishing pieces of good faith versus substantial compliance.
Thank you, Madam Chairman. I think in reality, it's going to be the same analysis. I allege you haven't acted in good faith. And then the response is, yes, I have, and here is why. I allege you have not acted with substantial compliance with the applicable rules and regulations. Yes, I have, and here's why. I kind of think they're just terms of art, and that in actual practice, they're not going to make a huge difference between what is alleged and then what is shown. And I think judges absolutely would have the right under Rule 12 to look at the law and see the immunity and say, I see what they did here. They acted in good faith. They followed the rules. They acted with substantial compliance. They filed the rules. The law says immunity. That's been a legislative determination that we want this. Case dismissed. I think judges absolutely would have that right today.
Any further questions from the committee? All right, seeing none, let's go to further public comment. I know it's getting late in the afternoon, but try to look awake, committee. Do your best. Do we have Mr. Boley?
Good afternoon, Madam Chairman. I'm here. You probably thought you'd seen the last of me after yesterday in Title 25, but I'm back like a fungus.
Great to see you.
Well, appreciate your time. And, you know, we're also members of the Wyoming Business Association, and we appreciate the work that Cindy's done. We also appreciate the work that Brad's done. We still have concerns, obviously. And I could get way into the weeds with you. When we look at the immunity that we believe that exists under the bill that was passed during the special session, we keep referring to orders, and in reality, there have been no orders given. The state health officer has given guidance, but we've actually pushed for orders, and it's been hard to come by. And so I have some concerns that we're relying on guidance as opposed to orders as our litmus test for immunity. The other thing that I think needs to really be, and I'm sorry, I'm with the Hospital Association and Leading Age Wyoming. I should have introduced myself. The other thing that concerns us is that there are cases that are mounting across the country. We haven't seen any here yet, but there are more cases that are mounting. We have been trying to do everything we possibly can in our long-term care facilities and in our hospitals, but COVID finds its way in. One of the problems that we see around the state is that individuals have their own rights, and they exercise those rights and those freedoms. And even with guidance that's been put out, we've seen folks that have decided that they don't want to follow the guidance that the state health officer has. So we have big fights over masking. We have fights over social distancing. We have all kinds of fights. Who's ultimately responsible for that? Who's going to be liable if COVID is introduced into one of our facilities? We've done best practices. We've done everything that we can to try and keep it out. We have folks that want to see their loved ones in our long-term care facilities, and they're mad because we're doing all we can to protect the most vulnerable. 75, 80% of the deaths are folks in their 70s. And so our long-term care facilities are ultimately very susceptible to this. And so we are just looking for assurances, and we're looking for protections to be put in place. And we don't want to be held harmless if we do something that is negligent and grossly negligent. That's not our intent. But we do want to have protections put in place when our healthcare heroes are risking their own lives and doing all they can to take care of families, patients, and their communities. And COVID just has a way of finding its way in. And I agree that proof is going to be difficult in some certain circumstances. But as a business owner and those that are actually caring for these people, I just think that we're really supportive of having additional guidance or additional protection put in place. And we appreciate your consideration, and I'd answer any questions.
Mr. Boley, I have a question. You indicated that the current legislation that was passed in the special session did not require health orders, and that is not accurate. So the good faith conduct does not require you to be in good faith with current health orders. And I think that comes from the good Senator Anselmi Dalton, who shared your concern that there weren't health orders in her county. And so she still wanted immunity for the businesses in Sweetwater County without the presence of a health order. So that current legislation was amended and passed. So there's no requirement to any kind of good faith to any kind of health order. That said, the TRW bill does require substantial compliance with a health order, right? And so how do you think that will play out if there is no health order?
Well, Madam Chairman, I actually thought that I understood the attorney from the LSO interpreted it saying that we had to have those health orders. And so maybe I misunderstood, but I actually think that this is me talking from a healthcare perspective. We have been asking for orders for a long time, and they haven't been in place. There's been guidance, and so I actually think that that's one of the things that we could rely on for that immunity. And I understand now what you're saying was passed in the original legislation, but as we've spoken with our legal team, we actually think we need more protection in place, that it's not sufficient to protect us.
All right, with that, Representative Stith.
Madam Chairman, thank you. Mr. Bully, thank you. On this issue of orders, I think I'm not quite following the discussion. When I go to the Department of Health website and I click on public health orders, there are, I think, 3 of them in effect now, and they're continuations, and they all say orders. So they all say orders. So do you believe that those orders are not actually orders, or are you talking about something else?
Mr. Bully.
Madam Chairman, Representative Stith, there are a few that are in place, but most of what we are receiving is guidance, and it's labeled and has been told it is guidance. We haven't been able to get specific orders signed, and we've been pushing for it since this thing broke out in March.
All right, thank you, Mr. Bully. I think there's no further questions for Mr. Bully. We'll go to Mr. Brown.
Thank you.
Chris Brown, who's waiting.
Thank you very much, Madam Chairman, members of the committee. Can you hear me okay?
You can, thank you.
Great, thank you. Madam Chairman, members of the committee, Chris Brown, representing the Wyoming Lodging and Restaurant Association, the Wyoming Travel Industry Coalition, and the Wyoming Retail Association. I'm here today to testify. We do strongly support the TRW bill that came through. Right out of the gates, I would agree with comments that Ms. Delancey made, in that we are not looking for blanket protection for businesses that are intentionally ignoring health standards and safety precautions. On the contrary, businesses across the state have every incentive right now to be doing the right thing. I know of numerous restaurants across the state where a staff member has become infected with COVID, and so many staff members had been in contact with that staff member that they've had to shut their business down until the quarantine period for potential infections was over. So I do believe that businesses in the industries that I represent do have the incentive to do the right thing. Our intent is to minimize the frequency that they would have to go to court to prove good faith effort. Restaurants, especially across the state, are largely small businesses that under normal circumstances operate on about a 3 to 5% profit margin. So even having to hire an attorney and go to court to prove that they did have good faith effort and do the right thing and get through that would be a particularly intense financial burden for them. In conversations that I'm having across the state with restaurant and lodging properties, they're down anywhere from 10 to 40% right now. And that's anecdotally one-on-one conversations. But throughout this pandemic, one of the biggest concerns I've heard from the industry is the concern of liability. And it's our intent to strengthen that to the greatest extent possible to minimize small business having to incur those financial burdens, Madam Chairman.
Mr. Brown, thank you. Do you think that the costs associated with demonstrating good faith would be different than demonstrating substantial compliance?
Madam Chairman, I don't know. I don't know that I'm not sure. I don't have the answer to that. But I do know that if someone's running a small mom and pop business and they need to hire an attorney to go in and prove good faith, I feel like the opportunity for them to have to do that is substantially more than if the bar is raised to where the plaintiff would need to prove gross negligence up front. I feel like there is additional opportunity under the we need to go and prove good faith compliance for small business to have to be taken to court and expend that revenue.
Thank you, Mr. Brown. Any further questions for Mr. Brown? Representative Washut.
Thanks, Madam Chair. Mr. Brown, thanks for coming today. I think I know the answer to this, but I want to ask just to make sure. How many of your member businesses have insurance policies that would shield them in this circumstance?
Thank you very much, Madam Chairman, Representative Washut. I can't give you a specific number. I'm sure that the vast majority of them carry some type of liability coverage through their insurance, but I can't speak accurately to how many would be able to cover them in this instance.
Senator Anselmi Dalton.
Thank you, Madam Chair. In actuality, I don't think there's coverage because even for business interruption, they exclude the virus. So a lot of them might not have coverage at all. I assume it's the same for death and other things that would happen. So I just would be concerned about any coverage for that for some of the businesses.
Senator Anselmi Dalton, do you think that there's coverage for a claim of negligence if someone were to slip and fall in your hotel?
Yes, there is. I'm not sure why the question, I don't understand.
I just wonder if it's not the same analysis for a negligence cause of action would apply for a defense as opposed to negligently contracting COVID.
Thanks, Madam Chair. I follow up just to say that for example, loss of business, they've said we exclude the virus. And I haven't looked at my hopeful insurance policy to say what happens if there's wrongful death to see if they also exclude the virus. I think they did that when they had the SARS vaccine. A lot of the insurance companies took out any kind of coverage, but I'll check with my insurance rep. Thanks.
Representative Washut, your hand is still raised. You have follow-up? All right, seeing none. Further public comment, we have, if you're next to speak on public comment on this issue, if you would go ahead and raise your hand or start your video. Looks like we have Mr. Larson.
Thank you, Madam Chairman. Can you hear me?
You can.
Thank you. Mark Larson with the Wyoming Petroleum Marketers Association and Convenience Store Association. Fuel distributors and convenience stores are considered critical infrastructure and essential services, and we were obligated to maintain and be open during the COVID-19 outbreaks. My goal this afternoon is just to help the committee understand extraordinary operational nuances that businesses are facing in this new normal. In terms of liability immunity, WPMA has great concern about legal exposure that is virtually impossible to mitigate or anticipate. The uncharted characteristics of COVID-19 have the medical community reacting to evolving analysis and guidance development that has many times reversed previous guidance on how best to address the disease. Businesses are doing their very best to keep abreast of new guidance, but make no mistake, at any given time, one can obtain conflicting or dated guidance previously thought to be best practice at that time. An example of this new normal is currently published or recently published in a national business law firm that our industry utilizes for legal guidance and legal advice. The legal alert is titled four common COVID misunderstandings that have placed a business at risk. The alert addresses the issue of shifting guidance that has been confusing and frustrating businesses in the community when determining what is current and recommended versus what is changed or outdated. The document states, quote, throughout the COVID-19 pandemic, the Centers for Disease Control and Prevention have issued constantly changing guidance for employers that many view as complex, confusing, and impractical. Given their complexity, some of these directives have often not been fully understood by companies. Further complicating matters, many of the recommendations have never been previously undertaken by employers, leading to misapplication. Worst of all, other guidelines are simply not feasible for some employers, leaving them with the tough decision of not knowing whether to follow the CDC directive order or just to stay in business. Continuing with the article, although it is an evolving area of law, Claimants Counsel will argue to courts that the violation of the CDC guidance is evidence of negligence, willful, or intent to on behalf of the employer. Plaintiff's counsel will assert that the CDC guidance has established a level of care or duty owed to the employee or other claimant that the duty was breached by the company. The article concludes by saying this is constantly evolving area with new guidance being issued nearly every day. The article obviates, Madam Chairwoman, the extremely precarious environment that every business owner is currently facing. With new guidance being issued frequently, I asked the committee, how is a business, how can it be held legally accountable for the lack of applying standards that are constantly evolving? WPMA believes that by not issuing an alleged emissions, by not assuring the alleged emissions of responsibility must meet the clear and convincing standard of LSO 33, will allow frivolous and settlement seeking claims to drag businesses before the court unnecessarily, primarily because due to the constantly changing and virtually impossible to keep up with guidelines. WPMA rejects the notion that good faith is a necessary due process position when legitimate claims of willful and wanton acts meeting a clear and convincing standard can be effectively proven. Due process is not eroded by assuring that frivolous and unwarranted lawsuits are eliminated prior to forcing the business to obtain counsel and go to court. Given the well-known documentation constantly changing guidance environment, the good faith answer is clearly inadequate for protecting businesses scrambling to keep up and meet the best practices and guidances of the day. Finally, and add to the scenario what Mr. Brown was addressing, and I heard Mr. Boley address, is the fact that many customers of good acting businesses, people that are applying the best standards that they know to be accurate, those customers simply ignore posted requirements such as the face mask mandates, often leading to confrontation. Any amount of good faith cannot anticipate or prevent such occurrences, thus obviating the need for a clear and convincing standard, making clear how the business acted egregiously or wantonly without subjecting the business to scrutiny for actions for which it had no control. Setting the standard historically developed in non-COVID times does not adequately address this new normal. I appreciate the committee's time. WPMA endorses the LSO 33, and we believe it is a critical need. Thank you, Madam Chairman, and I'll stand for questions.
Thank you, Mr. Larson. Appreciate your testimony. Just because I want to make sure it's understood, regardless if you think the other bill is better, the current law does not require compliance with the health order. So I just think that's an important concept. All right, questions of Mr. Larson?
Thank you, committee.
All right, thank you, Mr. Larson. Who do we have left that would like to speak on this topic? Ms. Wilkinson, are you here for this topic?
Yes, Madam Chairman, Catherine Wilkinson, representing American Property Casualty Insurers Association, and speaking in support of the TRW Bill 33. All of my concerns have been addressed, but I am happy to answer any questions for the committee.
Ms. Wilkinson, do you think that with the retroactive date that it poses a risk of the whole law being declared void?
Madam Chairman, I don't know if I have a direct answer for that. I do know that, the Supreme Court has spoken on it and does not necessarily advise it. But as Mr. Cave had stated earlier, I believe that there are ways, if the legislature specifies the need and lays it out exactly, that there shouldn't be too many challenges.
Thank you. Representative Washut, I see you waving. You're not on my screen, so it doesn't really matter if you wave, so that hand up does make a difference.
Thank you, Madam Chair. Perhaps Ms. Wilkinson's in the best position. As an insurer, do most insurance policies cover things like exposure to a disease like COVID?
Madam Chairman.
Ms. Wilkinson?
Historically, no. So pandemics historically have not been insurable. There's too much unknown. There's too much risk. So when you contract with your insurance company, they're looking at all of the risk. And in pandemics, there's just too much unknown. So no. There are, Madam Chairman, I would add specific exclusions that insurance companies may seek through regulators that would provide a specific set of insurance for that. We are seeing that the reinsurance for those insurance policies is shrinking, but that is a way that the insurance company in general is trying to address the pandemic by specific policies for that specific area.
Representative Wash, that's a good topic. Ms. Wilkinson, the distinction, I know we heard the good senator from Sweetwater County indicate that there was no business interruption coverage for a pandemic. Do you believe one of these causes of action would be considered a negligence claim, or do you think it would be some type of contagious disease claim?
Madam Chairman, likely a contagious disease claim, but we have seen several lawsuits in a lot of different states, not Wyoming. And a lot of those lawsuits are in fact against insurance companies, I think, to answer that very question. So I do not have that, but I will say that traditionally they have not been covered under insurance policies.
All right, thank you. All right, further questions? And is there any further public comment? All right, seeing no, there's a Bob that's listed, and I don't know who Bob is.
Madam Chairman, this is Bob McLaurin from WAM. I'm waiting for another COVID bill. Sorry.
Oh, you're good. Okay. Just wanted to make sure. We should add your last name to that list. All right. So committee public comment is closed on this topic. Discussion. Representative Stith.
Madam Chairman, perhaps I should have asked this question earlier. We didn't focus a lot on the burden of proof in the Travel and Tourism Bill 133. There's this heightened burden of proof, and it may take a little bit more time, but I just wanted to, if it's possible, to get response both from, say, Mr. Aronowitz or maybe from Mr. Cave. They would have different positions, I would think, but why would you have a different burden of proof in this case as opposed to any other tort action?
Mr. Cave, Mr. Aronowitz, if you're still around, if you could turn your video on and be prepared to answer that question. Mr. Cave.
Thank you, Madam Chairman, Representative Stith. The purpose of the enhanced burden of proof is, as Ms. Delancey discussed earlier, to require that a plaintiff come forward and be able to prove that it is highly probable that the allegations that they acquired COVID-19 from a particular source, from a particular person or entity, it's a heightened standard of proof. And in fact, it's there to reflect some of the things Mr. Aronowitz discussed about the difficulties in proving transmission of this particular disease, but also it recognizes the uncertainties of what a business owner has to face in order to do business in the environment with this disease. So there's really two sides to that coin, and it's there again as an added level of protection for Wyoming businesses when COVID claims are brought.
Mr. Aronowitz, would you like to take a stab at it?
Yes, please, Madam Chairman and members of the committee. Switching to video, I think an enhanced burden of proof with the law existing the way it is right now is just completely unnecessary. As a plaintiff's attorney, all that I would have to work with right now is a claim for acts or omissions constituting gross negligence or willful and wanton misconduct, because there is already existing immunity for everything else. So if I'm going to plead to meet that standard, I am going to need great facts, and I'm going to need support for them, or there's no point in filing a claim like that in the first place. That standard alone is going to ensure that there's going to be a higher burden of proof, because that's already an extremely difficult standard to meet. So changing burdens of proof and evidentiary standards is still, it just seems totally unnecessary and overkill to me if, again, immunity is already there.
Representative Ponnell?
Thank you, Madam Chair. I guess my question is, are we, well, we have a choice here of two bills, the TRW and then the one that the Judiciary. If we decide we want to go with TRW, are we going to kick it back to them to where they'll be voting on to proceed with this, or are we going to have a vote on which bill we would like? I mean, at this point, from the testimony, I can see that, and from what's in the bill, that the TRW seems to protect the businesses and the folks in the state much more than what the bill that this committee has come up with. So I guess how are we going to proceed on that?
Well, that will be up to the committee. So, I mean, that's a great discussion. Are there any further questions of the witnesses right now? And then we can, last call. Public comment is really closed here. So I think there's a number of ways to proceed. I saw Mr. Fuller pop on. If Mr. Fuller wanted to give guidance here at all, or
yeah,
I know it's time to listen.
Chairman Othercott, Representative Pennell, just to answer your question directly, where that TRW bill is, that committee voted to sponsor 21 LSO 33 as their committee bill. So, you know, I suppose if this committee prefers that bill, it need not take any action. If there is whatever session comes next, I believe it's that committee's intent to introduce the bill, at which point, you know, that bill would be kind of more open for discussion. You know, for now, I think, you know, probably the more salient question, if the committee does not prefer that, what it would want to do with the bill draft in front of it, which is 108.
Representative Ponnell, any further questions? All right, further discussion.
Madam Chair,
yeah.
He answered my question, so thank you.
Right, great. Further discussion from the committee? Representative Stith?
I would move adoption of LSO draft 108.
Is there a second? I'll second it. For purposes of discussion. Senator Anselmi Dalton.
Thank you, Madam Chair. I just want to weigh in just briefly to say, first of all, if we get to January and that's where we're finally looking at this immunity, that's a long time out. The public health order could have already been lifted. So I'm just glad that we have something in place already to protect the businesses. And though it was, I know, controversial, I still feel like the action at least gives businesses some safety net in opening up. It may not have been perfect because it was kind of done on the fly, as modified obviously by the concurrence committee. But January is a long way off if we're not going to have a special session. So as a business owner, I'm glad I have something, whether it is just good faith. But I think the TRW bill, I like the heightened standard because of the fact that as a business owner, you don't want some frivolous lawsuit. It's nice to have a higher standard so you don't have to lawyer up as long and hard, hopefully. I don't know if that's the case, but that would be my initial impression. And I do not like necessarily the backward look because I think we already have something in place to protect the businesses that will go all the way until the legislature finally meets and approves a different bill. So I'm not really worried about the backward look. And I do understand substantial compliance versus good faith. I think that's a question probably for you and maybe Representative Stith and Representative Pelkey to give us guidance on. I don't know if that makes a big difference when you're getting into lawsuit land, but overall, I feel we're in pretty good shape. We're covered. We're okay for now as a business owner. Beyond the good faith requirement, that is that, you know, there's the triple legs of immunity. You can have immunity if you follow the state health officer. You have immunity if you follow the local health officer, if they give you orders, and without orders, you have it if you act in good faith. So that is there, and I own a business. I feel pretty protected right now. I feel like I'm doing everything I can in good faith, and I think I would win my lawsuit. So thank you.
Further comments, Representative Stith?
Okay, and Madam Chairman, I don't want to burden the committee with too much debate or time, but if we're going to work this bill, I think there are a couple of amendments that would make sense if we're going to vote on a good bill. And so I would move to amend LSO 108, page 5, lines 9 and 10, by deleting the words civil actions alleging.
Seconded by Senator Boner. Any discussion? Mr. Fuller?
And Representative Stith, Chairman of the Representative Stith, I just wonder too then if you would want a similar change on page 8, line 16, where the reference is to claims alleging.
Yes.
Madam Chair.
Senator Anselmi Dalton.
Madam Chair, and also on the bottom of page 4, into the very last line 29 up to line 1, I guess, then, Representative Stith.
Senator Stith, yeah, that looks like that's a conforming amendment.
Mm-hmm. Thank you.
Discussion on the amendment. All right, all those in favor, raise your hands. So that's 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12. 12 in favor. All those opposed, raise your hands. 1 opposed. All right. Representative Stith, do you have further amendments?
Madam Chairman, yes, thank you. I appreciate your patience here. The next amendment would be on, let me get the right page. On page 4, lines 24, delete. So on line 24, after the word who, delete in good faith follows and replace with is in substantial compliance with orders, guidance, or, and then it would continue with instructions of.
Is there a second? Seconded by Anselmi Dalton. Discussion on the amendment. Representative Gray.
Yeah, thank you, Madam Chairman. Never mind. My question's answered. Thank you.
Question for Representative Stith on his motion. Is this the effort to remove that good faith requirement in complying with a health order?
Madam Chairman, yes, the purpose here is to, instead of having a good faith standard, to have a substantial compliance standard. And then the addition of the words orders and guidance, as well as instructions, is to close the gap that Mr. Boley referred to.
Sure.
That's the purpose of it.
All right, further discussion? All right, all those in favor of Representative Stith's motion, raise your hand. 5, 6, 7, 8, 9. I see 9 hands raised. All those opposed, raise your hand. 4 opposed. So that motion has passed. Representative Stith.
Okay. Madam Chairman, again, thank you for your patience. One last final amendment, not quite as important, but the motion would be to amend LSO 108 to adopt the staff's recommendation that we delete the findings. So that's the first few pages of it, just because I think by the time we're voting on this in February of 2021, these findings may or may not be as relevant. So again, not a matter of substance, just more a matter of style and presentation.
Seconded by Anselmi Dalton. Discussion on the amendment. All those in favor, raise your hand. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10. 10 in favor. All those opposed? 1, 2, 3, Three or four opposed. That motion has passed. Representative Parnell, you don't need to wave at me if the light's on. It's just I'm not looking. Representative Parnell.
Thank you, Madam Chair. Here again, I'm not being an attorney, but I want to make sure that with, I still favor the TRW bill, but does this eliminate, with what these amendments have done, and maybe this is a question for Representative Stith, does this eliminate the frivolous lawsuits and the actuality where you have to go out and hire an attorney and go through a long process to finally get it thrown out of court? I mean, that's from what I'm gathering from the TRW bill. I mean, that's what that does. It eliminates those upfront frivolous lawsuits, but it doesn't give way to the folks that actually are negligent in what they're doing. So that's why I'm just curious on all these amendments. Does it compare now to the TRW bill? That's my question.
Representative Stith.
Madam Chairman. No, it doesn't weed out frivolous lawsuits. I don't think the TRW bill does either, actually, because it's left up to the imagination of the plaintiff's lawyer of how frivolous they want to go. The big difference is, as I see it now, between this bill, 108 as amended, and the TRW bill, is that the TRW bill does require that you have plead with particularity and that you have the heightened burden of proof. So those are two pretty important differences in the TRW bill that are not in our draft 108.
I have a question for Representative Stith and Mr. Fuller, actually. Page 5, lines really 15 to 17, where we have this immunity applying to hospital clinics, long-term care facilities, county and municipal political subdivisions, special districts, healthcare providers that are retired. This list has always made me very, very nervous because it excludes some public entities. It doesn't identify the state, for example. So that's missing from the list. And then in addition, what do you think is the interplay between this and governmental immunity, governmental actions?
Chairman Nethercott, that's basically the basis of the staff comment on pages 6 and 7. And really, the question that staff comment raises is, the term that's used in this bill draft is any person or entity. And given the breadth of that language, whether really any of that definition is needed from page 5, line 11 through the end of page 5. In terms of the interplay between the Governmental Claims Act, I guess two thoughts in response to your question. First, the fact that we are listing specific entities here to the exclusion of others may, could in theory lead a court to say that those entities are not included in this immunity that's provided here. And then the second would be indeed, whether, for a lawsuit alleging facts that implicate this immunity, whether this takes precedence over the Governmental Claims Act or the other way around is unclear, from the language itself.
Senator Anselmi Dalton.
Thank you, Madam Chair. I think given Mr. Fuller's explanation, and we've heard this multiple times from him, is the more we list it out, the less the Supreme Court is likely to include anything else. I would move to strike on page 5, lines 11, starting with word as down to the line 22, and just leave it person or entity on page 4. And I'd ask for a second.
Second.
Moved by Senator Anselmi Dalton, seconded by Representative Stith. Discussion on the amendment? All those in favor of Senator Antonio Dalton's motion, raise your hand. One, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11 in favor. All those opposed? One is opposed. Or no, 2 were opposed. Okay, committee, further discussion on the bill? Representative Jennings.
Yeah, I don't know. I'm concerned with this one. It looks to me like we're paddling upstream. I didn't hear any testimony that anybody's going to jump in behind us. Maybe doing these amendments will. I don't know. Not seeing it, and even Chairman Nethercott's comments that we already have immunity in place. I don't think I'm going to be able to support this either way. So I guess that's my comments to it.
Representative Salazar.
Thank you, Madam Chair. I favor the TRW bill, and we'll be voting against this. Thanks.
Representative Washut.
Thank you. Very briefly, I put myself in the shoes of a business owner, a guest rancher or something. If my insurance isn't going to, give me any type of protection in these circumstances, I stand to lose the entire ranch if there's a successful wrongful death lawsuit. I just lean towards the TRW bill. I hope that some of our witnesses are correct and that we have adequate protection in place. But I just think the stakes are really, really high for some of our business people. I'll be a no vote.
Senator Boner.
Thank you, Madam Chair. Just briefly, I agree with a lot of the previous speakers that I favor the TRW committee bill as well, but I'm going to support this bill because, it's a rapidly evolving situation. We don't know if we'll be in a special session, whether it be November, December, or the regular session in January. At this point, I think it's premature to conclude that one bill is better than the other when I haven't seen the TRW bill, first of all. And second of all, we don't know what the situation is going to be once we actually might be voting on this in whether it be a regular or special session. There's not a whole lot of harm in moving the bill forward. I just like to keep our options open and reflect the good work of this committee, which by rights, a topic like this is probably best suited for judiciary. So I'm going to be voting yes, just to keep our options open.
Representative Gray.
Yeah, thank you, Madam Chairman. I'm going to be voting aye on this bill too. I do want the record to reflect that does not reflect any opposition to the TRW bill, but I will be voting yes on this. Thank you.
Yeah, I too am an aye vote on the bill for the same reasons of Senator Boner. I think it's important for us to have something moving forward. The process has been frustrating, of course. So I think this is good work. I think it's all an overreaction. But nonetheless, this is the storm that we're in. So we will continue to survive it. Representative Burlingame.
Thank you, Madam Chairwoman. I'm actually going to break a little bit from precedent and say I'm an aye vote on this, and I'm an aye vote on this. Maybe it's a failure of imagination on my part, but I like a much cleaner process that I can follow and that's linear. And I didn't like finding out from a lobbyist that our bill was in another committee. I wasn't aware of that, and it's not a process that I want to see reinforced by rewarding it. So I think we worked hard on this one. I think there's a lot of things that will, like everyone has said before, we'll see where they land. We'll see where we are in January. I don't think any of us can possibly speak with any authority as to what this will look like coming up on January, or even who of us will be at the table. I include myself in that. So I hope that folks will vote yes on this one and give us the opportunity to have this option coming up into either a special session or our next session.
Further discussion, Representative Ponnell. I want to move back.
Thank you, Madam Chair. I do like the TRW bill, but here again, I think I will vote in favor of this bill just to continue it down the path. Because if we do go into special session, there may be a need to have judiciary involved. So I don't know if we're going to have special session or not. That's that question that everybody wants to know, I guess. But anyways, I will be a aye vote. Down the road, I may change though.
All right, good committee. Are we sensing you're ready for the question?
Question.
All right, roll call vote on the bill. Mary Beth?
Madam Chair, this is a roll call vote on 21 LSO 108, version 3 as amended. Senator Anselmi Dalton.
Aye.
Senator Bonner.
Aye.
Senator Koss.
Aye.
Aye.
Yes, aye.
Senator Von Flater.
Excused.
Representative Burlingame. Representative Gray.
Aye.
Representative Jennings.
No.
Representative Pelkey.
Aye.
Representative Ponnell.
Aye.
Representative Salazar.
No.
Representative Stith.
Aye.
Representative Washut.
No.
Co-Chairman Kirkbride.
Aye.
Co-Chairman Nethercott.
Aye.
Madam Chairwoman, I believe that passed.
All right, good committee. On to our next COVID bill, a kind of random one. Mr. Fuller, are you prepared to explain this, or Mr. Hopkinson? The Municipal Services Recovery Actions, LSO 91.
Madam Chairman, I will be walking through that one for the committee. And I'm looking at 21 LSO 91 working draft 0.3. This comes before the committee upon a request from the June meeting that 2019 House Bill 105 kind of come back. This bill is based on that bill. Essentially, the crux of the bill is found on page 2. What it does in subsection A, it provides that a city or town that operates trash, recycling, water, sewer, gas, or electric services, that they shall not collect or attempt to collect past due payment from a property owner when the owner has not contracted with the city to provide those services. And subparagraph B, or subsection B, provides, or rather prohibits, that city or town from requiring a property owner as a condition of providing those services to contract with the city or town where that owner does not, where a tenant rather resides on the property and not the owner. Section 2 at the bottom of page 2 simply provides that nothing in the act should be construed to modify or impair any existing contract executed before the effective date of the act, and the effective date would be July 1st, 2021. And with that, I would stand for any questions.
Thank you, Mr. Hopkinson. Representative Stith?
Madam Chairman, Mr. Hopkins, if you know, what's the social evil that this is designed to address? What's the problem that we're trying to fix?
Why are we doing this, Mr. Hopkinson?
Madam Chairman, Representative Stitt, this goes back, I think, to that June meeting as far as the specific evil designed to be addressed. What the bill does is simply prevent a municipality or a town or city from recovering from a property owner when the property owner wasn't the individual to make the contract. So in a landlord-tenant situation, if the tenant has past due bills that are contracted in the tenant's name and does not pay them, this prevents the municipality from recovering from the property owner and prohibits that requirement that the property owner contract directly with the city. As far as the purposes behind that, I would defer to those to others on the committee who were wanting this bill drafted.
Representative Washut.
Thank you, Madam Chair. As I recall the discussion, it came up in the context of some of the discussion on evictions and not being able to remove tenants during the COVID period of time for failure to pay rent. And the concern of property owners that during that time period where no rent was being paid, no utilities were being paid, and then eventually the tenant leaves with several months of unpaid water bills and so forth left behind, that municipalities were frequently coming back on the property owner for all of that unpaid water bill. And so this was designed while we were talking about trying to protect tenants. The landowners, property owners said that they too had some exposure during this time period and even before and after COVID to these circumstances. And the simple solution was for the utility to simply set up their contract, get an upfront payment or pay in advance kind of situation with the tenants rather than come back on the landlords at a later time.
Representative Washut, that was very helpful. Any further questions of Mr. Hopkinson? All right, seeing none, we'll go to public comment. I see we have Bob, Mr. McLaren. Good to see you. Please introduce yourself to the committee and look forward to hearing from you.
Madam Co-Chair, thank you. My name is Bob McLaren. I'm with WHAM, and this is a bill that I think came about a couple of years ago. WHAM is opposing the bill. We think this is a matter of local control. Given all the issues facing the state, we don't think that it's appropriate for the state to try to take the power away from cities and towns of how they manage their utility systems. We believe that's something between the customers and the folks who operate the utility, whether it be a city or the power company or whomever. So WHAM opposes the bill and asks you not to pass it.
All right, thank you, Mr. McLaren. Any questions for Mr. McLaren? Well, thank you for hanging in with us today. I know you've waited for quite a while. We appreciate your patience.
Well, thank you.
All right, further public comment. I think we have Ms. Gleam. Hope I'm pronouncing that correctly.
Yes, you are. So my name is Julie Gleam. I'm with the Cheyenne Landlords Association. We're asking for the passage of this bill for a couple of reasons. Prior to COVID, landlords were frequently on the hook for up to $600, $700, $800 if a tenant would move out and leave an unpaid water bill. Sometimes this gets aggravated if there's also some type of agreement with like Black Hills Energy. When COVID hit, the landlords were asked not only to defer significant amounts of rent, all of my public landlords, which are Cheyenne housing landlords or they have some type of FHA agreement, have not been able to evict since March 15th. So they've gone without 6 months of rent, and now they're also on the hook for, from that time frame until August 10th, they were also, tenants were not told that they did not have to pay utilities, and some of them didn't. And we now have tenants that are looking at paying upwards of $3,000 in utilities. Roughly a third of those happen to be water, and water tends to be the biggest sore spot because it's the one that follows the property owner. These tenants are playing a game where they know they don't have to pay. All we're asking is that the water companies and the municipalities collect a deposit similar to the same way that Black Hills does to collect deposits for water. And then if they don't pay, theoretically, the utility company would have a 3-month payment of water in their pot. So when this tenant doesn't pay their bill, that deposit can pay that water bill. In Cheyenne, the reality is water bills go unpaid. And in Cheyenne, the city, from its general budget, pays into the water company's budget somewhere between $50,000 and $250,000 a year for unpaid water bills. There's no need for this if we get those deposits on board. And the only way we can get those deposits on board is to have the municipalities collect them.
Questions for Ms. Gleam? Thank you, Ms. Gleam. Appreciate your feedback. All right, I don't believe that there's any further public comment on this topic. Committee, any final questions? Senator Anselmi Dalton.
Thank you, Madam Chair. I guess I would ask Mr. McLaurin, maybe Ms. Gleam also, I mean, who has more control and ability to control these things? It's, to me, in a way, I would think maybe the city has better control because they could shut the water off. Maybe not during the COVID, when I don't know how that goes, but and maybe if Black Hills is doing this, I mean, obviously we all like local control, but if Black Hills is able to get a deposit, I mean, the city's the one that knows whether their bills are being paid. And I think in my business, I have to collect my bills, and maybe the city has to collect its bills, and shouldn't it be foisted back on the landlord just because they have a deep pocket? So I'd just like to have some comment from both sides on that thought.
Yeah, Mr. McLaurin.
Madam Chair, Senator Dalton, you know, we don't necessarily disagree that a deposit is a good way. A number of cities around Wyoming do that. Our issue with this is an issue of local control. The state doesn't need to be dictating to cities and towns of how they manage their utilities. This is my understanding primarily an issue of Cheyenne. The Cheyenne Board of Public Utilities and the Cheyenne City Council should be dealing with it, not the Wyoming State Legislature. Yes, the cities should, I mean, like I said, they should be doing it. We don't object to doing the deposit. It's just, it's an issue of the cities know what's best of how to manage their utilities is our position on the matter.
Ms. Gleam, did you want to comment on that?
Yes, we have been to the Board of Public Utilities in Cheyenne. We've been to the city of Cheyenne, the city council here. They have both thrown it back to the legislature and said they're unable to collect deposits because the legislature says no. And that's why we came to the legislature, because the city and the Board of Public Utilities were saying no. As far as answering Ms. Anselmi Dalton's question as well, a landlord can't shut off the water. That comes from the city. Frequently, the landlords aren't even aware that the bill has gotten so high. That depends on if the city has let them know. A lot of times these bills are 2-3 months past due before the city says anything. And so the landlord just feels like they're a sitting duck on this. And to be very frank, those bills that don't get paid by a tenant and get passed on to the landlord ultimately causes the landlord to pass that on through the way of higher rents.
All right, thank you, Ms. Gleam. Senator Cost.
Thank you, Madam. My concern is, number one, unless I'm interpreting it wrong, I don't see this as having anything to do with COVID. So obviously this is something that would go into effect on a permanent basis rather than just during a time like this. And I really do think this is a local control thing. I struggle to say that we should step in and say, no, this is the way you've got to do it for all of the state. I think towns need to work with the landlords. I think it's important that they get together, find a solution, but I really struggle with it. I don't know. I'm struggling with this one.
It's a hard day for Cheyenne too. Any further comments, discussion, questions? Senator Boner?
I guess a question for Wham then, since we're hearing about local government in Cheyenne saying that they can't do anything about it, I just want to hear Wham's perspective definitively. Is the Association of Municipalities saying that the municipality can in fact deal with this issue, and perhaps Board of Public Utilities in Cheyenne was off base there?
Madam Chair, Senator Bonner, as my understanding, there's no legislation about this, that cities that run utilities and garbage services have complete discretion of how they deal with those utilities. I don't know of any legislation that dictates how it's done, because as I said, for example, the city of Cody gets a deposit and they get 3 months deposit. The town of Jackson goes back to the landlord. So it's a mix. I mean, there are 99 cities and towns in the state and a number of utilities, and they all do it a little bit differently. So there's no mandate, as we understand it from the state, of how to do that.
Senator Boner.
And just to follow up, maybe, in case this bill doesn't move forward, perhaps that's something Wham could share that information with all their members, make sure all the tools at their disposal.
Absolutely.
All right, further questions for Ms. Gleam or Mr. McLaurin? Senator Cost? No? All right, with that, public comment is closed. Representative Washit?
Move the bill.
Was that seconded by Co-Chairman Kirkbride? All right. Moved and seconded. Discussion on the bill. Representative Washit?
Thank you. I think we heard testimony from Wham that a large number of our communities around the state already do this. It just seems to be an interest of fairness. Not all of our landlords are these great big housing development type folks. A lot of them are your neighbors, small people, small homeowners that rent a second house, and then their landlord or their tenants move out and stick them with this big water bill. To me, a uniform practice seems to be in order, and I think it's a reasonable piece of legislation we ought to move forward.
Further discussion? All right, seeing none. Roll call vote on the bill. Mary Beth.
This is a roll call vote on 21 LSO 91 version 3. Senator Anselmi Dalton.
Aye.
Senator Boner.
No.
Senator Koff.
No.
Senator Von Flatern.
Excused.
Representative Burlingame.
No.
Representative Gray.
Aye.
Representative Jennings.
Aye.
Representative Pelkey.
No.
Representative Parnell.
Aye.
Representative Salazar.
No.
Representative Stiff.
No.
Representative Washit.
Aye.
Co-Chairman Kirkbride.
Aye.
Co-Chairman Nethercott.
Aye. What's that vote?
7-6.
7-6.
What was his
Chairman Nethercott, by rule of the committee, with the Senate voting 2-2, that motion would fail.
All right, that motion has failed. Thank you, Mr. Fuller. All right, committee, why don't we take a quick 10-minute break, and then we'll move into our last topic, or close to last topic of the day, public records. Does everyone feel comfortable with that? Good. Okay, quick 10-minute break. We'll come back at 2:53. Hey, committee, just looks like we're waiting on some LSO staff to join us, and then we'll start up again.
Madam Chairwoman, I just dropped the share, so.
Wonderful. Oh, and there's a quorum. All right, everyone, welcome back. We'll start up our next section of public records. We'll start with the topic summary. That's Mr. Fuller.
Yep. And Chairman Othercott, just by way of, kind of a roadmap, I'll briefly cover the exceptions to the Public Records Act, which I understood to be the focus of this year's coverage of the Public Records Act by the committee. I'll then dive a little deeper into personnel file. By request of the chairman, there's a separate memo that you should have received with your materials for personnel file and how other states have handled that before turning it over to Ms. Creech to discuss the results of the survey that was commissioned regarding the exceptions to the Public Records Act. So just to jump in, generally, the Public Records Act requires disclosure of records. All records shall be open for inspection. The Wyoming Supreme Court interprets the Public Records Act to favor disclosure, and to that end construes the exceptions narrowly. Generally speaking, the right of inspection to public records exists unless it's contrary to a state statute, contrary to a federal law, or prohibited by the Supreme Court rules or by court order. There are two types of exceptions that are delineated in the Public Records Act. The first, I guess I would characterize as discretionary exceptions. The custodian of the public records may deny disclosure if the disclosure would be contrary to the public interest. Just to run through at least the notable ones that the Supreme Court has interpreted or opined on. First, records of investigations and security procedures of law enforcement. And this would include any investigatory files that are compiled for law enforcement or prosecution purposes. The Supreme Court has held that the documents are those that are related to law enforcement and prosecution purposes, but it's not a blanket exception. So for example, a police department cannot withhold an entire jail log just because some material in that log may concern investigations. The next one I'll mention is intra-agency and interagency memoranda that wouldn't be available by law to a private party in litigation with the agency. The Wyoming Supreme Court has held that this exception incorporates the common law deliberative process privilege. And to examine whether a document would fall under this exception, it has to be a communication between or among an agency. It must be pre-decisional or deliberative, and then disclosure would not be in the public interest before an agency can avail itself of that exception. Generally, if a document doesn't reflect the agency's final policy, if they're weighing two different options, that would fall within the exception. Documents that simply restate a final policy decision of an agency wouldn't be covered by the exception. And documents that only have factual information as well and don't include the pros, cons, and so forth, that would not fall under this exception as well. There are other discretionary exceptions. They're listed in the memo. Those have not to date been interpreted by the Wyoming Supreme Court. Moving on to mandatory exceptions. These are exceptions in the Public Records Act that require a custodian to deny the right of inspection unless law expressly provides otherwise somewhere else. So medical, psychological, and sociological data on individual persons. I believe this was noted at the last meeting, I believe by the University of Wyoming. The Wyoming Supreme Court has noted that sociological data means information that social scientists collect in their study of sociology, and that by itself, the exception would not authorize withholding names and addresses of certain agency workers. Beyond that, there's no clear-cut definition of what sociological data is. Next is personnel files, except those files shall be available to the officials who supervise the person's work. It states that any applications or performance ratings or achievement data are available only to the person in interest and that person's supervisors. And then employment contracts and working agreements are not part of a personnel file and are available for public inspection. Next would be trade secrets. The court has considered this exception and tracks the definition of trade secret to be what the federal definition is in FOIA, which is basically a secret, a planned formula that's used to make, produce, or prepare commodities, for example. It's information that is used or involved in the productive process itself instead of collateral matters. The court noted that the rationale of this exception is to encourage cooperation in terms of providing information to a governmental entity. For example, providing information regarding, processes for fracking, or drilling oil and materials that may be used there for proper inspection by the Department of Environmental Quality. The next one I'll note is hospital records related to medical administration staff or personnel, as well as medical care. The court has held in a case that information regarding a financial inducement that's paid to, say, a healthcare provider to come to a Wyoming hospital or medical or healthcare facility was not exempt under this exception. And only records where disclosure would be an unwarranted invasion of privacy would fit under that medical exception. Next one I'll note is records or information compiled solely for purposes of enforcing internal personnel rules. The court has noted that this applies only to records exclusively compiled for investigations of violations of those personnel rules. The remainder of the mandatory exceptions have not had occasion to be considered by the Supreme Court. Before I move on, I'm happy to answer any questions about those as best I can.
Representative Gray.
Thank you, Madam Chairman. Mr. Fuller, I'm really interested in this discretionary exception on application for the position of president of an institution of higher education. A lot of our issues have been with the university. So I find this one interesting. I mean, I guess, I want to make sure if the interpretation of this in the legislative history is, it's not just for during an application period, it is post period as well. So that, and I can understand some of this, but the application, I'm a little surprised by that is an exception. I want to make sure that's through the entire life. I mean, even after the decision is made, that they can choose to not even provide an application for president of the university. And my second question is, I imagine, I don't know if you had a chance to look at the legislative history on these, but if you did, I mean, is that because they think it might be chilling for people applying? Or, I mean, I want to understand a little more about this. Or is it personal information, in which case the application itself, I think, I don't know why that would apply. So, yeah, that's my question.
Chairman Ethercott, Representative Gray, I'll start with your second question first. I don't know the specific legislative history behind this exception. Generally speaking, though, my understanding, based on what other states have done, is that the exception is there to promote applications from individuals who may need a level of confidentiality with, say, a current institution at which they serve. Again, I don't want to speculate on the legislative history of this specific exception. That's just more of a general answer. To your first question, there is nothing in here, or I'm aware of in the Public Records Act, that attaches a temporal limit to when a record is covered under an exception. I think without that language, it seems to me that, an application for the position would be exempt, anytime it's requested, whether it's a week after the application is submitted or 10 years. I don't see anything in here that suggests that after a period of time, the record would lose the protection of the exemption, if you will.
Further follow-up? Anyone? All right, Mr. Fuller, if you want to proceed.
Sure. Now I'll move on just briefly to the definition of personnel file. This was also raised at the May meeting as one area of, where clarity was, may not be the best in terms of what is or is not a personnel file. At the chairman's request, there's a separate memo basically describing how other states treat personnel files. And the first point I'll note is that I only found in my research one state where they had a separate definition of personnel file in its Public Records Act, and that was Colorado. It basically defines personnel file to mean home addresses, phone numbers, financial information, relationships, other information maintained because of an employer-employee relationship, but does not include applications, employment agreements, any amount paid or benefit paid, performance ratings, or any other compensation. So to that end, it tracks somewhat with how our definition or how our exception is worded, but that was the only state that I found a specific definition in its Public Records Act for what a personnel file is. Moving on to the remainder of the memo, this just basically compiles what other states' Public Records Acts provide in terms of exemptions for personnel files. So for example, Colorado excludes personnel files except to the person in interest and the supervisor, but it doesn't prevent inspection of employment contracts or amounts paid in line with that definition. Illinois provides that personnel information for which disclosure would be a clearly unwarranted invasion of personal privacy, would be exempt from disclosure. And they've defined that as highly personal or objectionable to a reasonable person, and where the right of privacy would outweigh any legitimate public interest. Utah outlines private information for specified government employees that is exempt from disclosure. Generally, those specified employees tend to be in the law enforcement area. Utah also outlines a procedure for how an employee can request for that information to be kept private, and the scenarios by which that information could be disclosed. For example, by a subpoena. Idaho exempts all personnel records except employment history, pay, classification, and salary history, and requires written consent before any other information, demographic contact information, can be disclosed. Ohio excludes designated residential and familial information only. Vermont excludes personal documents that are related to the individual, including information on hiring, evaluating, promoting, and disciplining, personal finances, and medical information, which would only be available to the employee. Oregon has a similar to Illinois in terms of personal information would be excluded if it's an unreasonable invasion of privacy, and unless the public interest by clear and convincing evidence requires disclosure. And then finally, at the end of the memo, there were a couple, I did find other statutes, and this would be on page, beginning on the bottom of page 10, where other states have defined personnel file for other purposes. So for example, in the labor context, personnel file is defined in Colorado. North Carolina defines personnel file for their human resources statutes. A couple of other states, Louisiana, for example, defines it specifically as it relates to school employees, and that's on the last page of the memo. With that, I'm happy to stand for any questions.
Thank you, Mr. Fuller. Questions of Mr. Fuller about this particular piece? Representative Gray.
Thank you, Mr. Fuller. Thank you, Madam Chairman. I'm interested in this Utah exemption because I'm interested in the concept of on the personnel file. We have a few employees, a few people that are, I would say, in high up management and very high profile positions, thinking the president of the university, where it's possibly a little bit of a different situation. And I think that's one area of our conversation. And so one, I mean, I guess outside of the context of Utah, did you see any state that tries to differentiate maybe a couple positions that are high profile and or differentiated in some way? And then in this Utah exemption, am I reading this right, or the Utah statute, am I reading this right, that the default is that the personnel file is open and employees have to, they need to identify that they want their file as private, and then at-risk government employees have to as well, and then they provide that definition? I mean, it seems like at the top here it says that they're private if the current or former employee identifies them as private on page 3 in the middle of the page. So I guess there's kind of this thing where someone has to write a letter, and the default is that it's not private. Am I reading that right? So those are my two questions.
Mr. Fuller?
Yep. Chairman Ellicott, Representative Gray, to your first question, you know, in my quick research, I did not see another state that employed a specific framework like this for certain, you know, personnel and employment records. In terms of your next question, this would require that at-risk government employee who's defined, you know, who's delineated, specific employees are delineated, as well as just state or local employees, you know, by nature of their work, you know, would be an immediate and substantial risk if that information is disclosed. So the way I understand the statute to operate is that a government agency actually has to prepare a form to make available to these employees that the employees could then fill out, give back. Once they give that back, that form basically remains in effect, I believe, unless rescinded or revoked, for 4 years, at which time, you know, that employee would fill out the form again to continue availing themselves of that protection.
Follow up, Representative Gray? All right, further comments or questions? Thank you, Mr. Fuller. Do you have anything further? We have Ms. Creech.
Yep. Ms. Creech will go over the survey results, and then after we cover the public records, I'll come back and give a brief overview of the Public Meetings Act.
Thank you. Ms. Creech?
Thank you, Chairman Medicott and Co-Chairman and Committee. So today I'm going to be providing an overview of the survey sent out on behalf of the committee at their request at the May meeting. The purposes of this survey were to assess the challenges associated with applying the Wyoming Public Records Act, as well as to determine how often state and local entities are utilizing legal counsel in order to comply with the act. So the survey was sent to a variety of state and local entities around the state, ranging from large agencies to small political subdivisions. If you flip to page 2 of the report, you'll see a breakdown of the respondents, but the data was de-identified to encourage honest and open communication. We had a total of 155 respondents from around the state. And approximately 31% of responding entities stated that they do face challenges associated with reviewing documents and applying exceptions to the Public Records Act. If you're interested in looking at the specific survey questions, those can be found as an attachment to this report. The most cited challenges were small staff sizes to respond to the public records requests, so that just that time intensity that is associated, and then unclear procedures for remote or online meetings, but that has to do with the Public Meetings Act, so I'll move past that. Several entities indicated a desire for an online resource on the governor's webpage for better guidance in applying the Public Records Act. Further, several entities expressed interest in regular training opportunities to minimize the need for legal review. And many entities also expressed a need for clarity regarding the role of the ombudsman and would like further information to help avoid small staff offices being overwhelmed. So moving to the legal review portion of the survey, we did ask entities how often they send public records requests for legal counsel to determine whether those exceptions applied to the public records requests. So of those entities who responded, 45% of respondents have stated that they sought legal counsel for public records requests in the last 5 years. Of those who have sought legal counsel, which is approximately 70 entities, 23 sent all of their requests for review by legal counsel, so 100%, and 29 entities sent 20% or fewer of their requests for legal review. So I will note that some entities that send 100% of their requests for legal review do have in-house legal counsel and indicated that in their responses. So moving along, 52 entities sent public records requests for legal review just for the primary purpose of determining whether exceptions to the Public Records Act were applicable grounds for denial. And almost half of all respondents stated that 20% or fewer of their requests needed legal review for that purpose. So as Mr. Fuller expressed to you all, there are two different sort of types of grounds for denial. I'll begin with the discretionary grounds for denial, and then I will pause for any questions that you might have. The survey asked entities to rank the top 3 most challenging discretionary grounds for denial to apply. And entities overwhelmingly indicated that the #1 most challenging was subsection B, subsection 1, which excludes those records of investigation for, sheriffs, county attorneys, city attorneys, state auditor, police department, etc. With individual responses, we did allow them to provide written feedback, and a few responses indicated that they would like specific language to protect entities such as fire departments and the state treasurer from legal challenges under this paragraph. Moving on to the second most challenging discretionary ground to apply was 203 subsection B5, which excludes interagency or intra-agency memoranda or letters, which would not be available by law to a private party in litigation with the agency. The respondents requested clarification regarding memoranda shared outside the state with other states or with federal agencies. And finally, the third most challenging exception was 203B subsection 6, which excludes information that would jeopardize the security of a structure owned, leased, or operated by a governmental entity. So this includes building plans, blueprints, schematic drawings, diagrams, operational manuals, or any other information that would reveal the building or structure's internal layout. Respondents were also asked whether any additional discretionary grounds for denial should be considered for inclusion into the Public Records Act. And those verbatim responses are actually included in the report if you're interested. There's quite a bit of nuance and there's quite a wide range of responses, but something that I noticed was a trend was that many individuals indicated that there was a struggle in fulfilling requests that were harvesting vendor information for commercial gain. So they indicated that they were getting these big requests from outside of the state for the purposes of selling that data, and because it fell under the Public Records Act, they had to provide that. They also indicated, student data and information in that regard, which I think, harkens back to their request for more training in understanding, how these exceptions are applied. So that's my subsection on discretionary grounds for denial. I'll pause for any questions before I move on to the mandatory grounds.
Thank you, Ms. Creech. Looks like we have one from Representative Washut.
Thank you, Madam Chair. Is this material in the meeting information? I don't seem to have a copy of this report that she's reading from.
Yes, it's online on the meeting materials with the agenda. It is called Wyoming Public Records and Public Meetings Act 2020 Update with an issue brief. So it's in that linked attachment on the online materials. So the public has access to it as well. Representative Gray?
Thank you, Madam Chairman. So, Ms. Creech, in the discretionary grounds for denial section, I just want to make sure no one answered that they will deny for keyword searches, correct? Because the statute does not allow for that, and I want to make sure nobody claimed that it does. So that's my question. I don't see it here, but I want to make sure, because I know those are often the most controversial. Thank you.
Sure, Madam Chairman, Representative Gray. I didn't see any responses that indicated any struggles with that. You're more than welcome in attachment B or appendix B and C. That actually includes all of the raw verbatim responses from every entity. And so you're more than welcome to look through there, but in my analysis, I did not find that that was an issue. I'm sorry, Madam Chairman,
I am muted. Representative Stitt.
Madam Chairman, thank you. Ms. Creech, thank you for this fine report and survey. I really appreciate it. It sounds like the number one problematic discretionary request was for under B1 for records of investigations. Any sense why that's problematic? I mean, it seems like if you're the police department, you say you either establish a policy that you're going to release police reports or you're not. And if you have the discretion not to release it, you just don't release it. So, I mean, is it that, did you have a sense for why they're finding it hard? I mean, is it that they feel like they don't have criteria to use to decide whether it makes sense to withhold, or is there some other reason?
Ms. Creech?
Thank you, Madam Chairman, Representative Stitt. From what I could gather, the biggest struggle with that was just general pushback with that discretionary ground. And so just requesting a little bit more specificity in terms of, what can be denied. Of course, some of these exceptions are quite broad, records of investigations conducted by. So I think that they're receiving a lot of pushback, and I'm not sure, but Mr. Fuller might have some more information on that.
Mr. Fuller?
Another Representative Stitt. I think part of the responses, or part of the reason why that response was put first, is that some entities believe that they are not covered under that exemption and should be. And noting the raw results, I believe the two that I saw spelled out were, I think, fire departments and the treasurer's office in those raw results. So not so much as it is a challenge to apply, but it is a challenge because we are not covered and want to be.
Interesting. Representative Stitt, follow-up?
Madam Chairman, thanks. And so for the state treasurer, I mean, the state treasurer is not out doing criminal investigations usually, but is there some reason the state treasurer thinks that their investigation should be secret? I mean, I'm just on the policy of it.
Just to kind of back up, I don't know that it is the state treasurer. It could be your county. I don't know. It just was listed, but just to clarify that piece.
Yeah, Chairman Ellicott, Representative Stitt, on page 6 of the report, about halfway through, and Danielle can correct me if I'm wrong on this, but I believe that response is a verbatim response that says add state treasurer to 203B1. and explains why. I presume that's their explanation why they want to be covered. In terms of whether they should or should not, that certainly is the committee's call to make.
Okay. Further questions from the committee? We'll let Ms. Creech finish her presentation. Thank you, Ms. Creech.
Thank you, Madam Chairman. Continuing on, for those of you who may have just found the report, I'm on the bottom of page 6, where it's entitled Mandatory Grounds for Denial. So very similarly to the discretionary grounds, respondents were asked to rank their top 5 most challenging mandatory grounds for denial to apply. The most challenging mandatory ground was under subsection D3, and that is regarding personnel files. Several respondents indicated a need for a tighter definition of personnel files in order to be able to properly apply that. Based on survey results, the second most challenging ground for denial is medical, psychological, and sociological data. And as Mr. Fuller discussed previously, that does apply to that sociological data, having a better definition of what constitutes sociological data and whether or not certain information is protected. The third most challenging was trade secrets, privileged information, and confidential commercial, financial, geological, or geophysical data. The only written response that I had to that, or in regard to that, was in regard to GIS data conducted or collected on private property. And respondents similarly were asked to recommend other potential mandatory exceptions to be added. And because there was such a wide range of commentary, I did provide those verbatim within the report. Employee information such as addresses and other contact information was widely listed, which goes back to the sociological data issue. And then there was also a request for sealed bid information as to retain competitive advantage. So those were 2 that stuck out to me, but again, those are provided verbatim for you to review. And with that, I will stand for any other questions that you might have.
Ms. Creech, thank you. Representative Pelkey.
Thank you. Ms. Creech, I'd like an explanation as to how law enforcement personnel files fall under the status quo and under the provisions of the measure that we're considering now. Obviously, my concern is procedures against law enforcement officers, and does public have access to that now, and would this improve the situation?
Ms. Creech or Mr. Fuller, if you know, and maybe I think Mr. Representative Pelkey is maybe asking some Brady material questions.
Thank you, Madam Chairman. I think my colleague Brian Fuller might be able to provide a better answer.
May I remind everyone he is a diehard defense attorney.
Chairman Ellicott, Representative Pelkey, you cut out there for a minute. I just want to make sure your question is basically looking at the discretionary exception for records of investigations, and then you had said something about what it covered. I'm afraid I didn't quite catch that part.
What I'm is disciplinary hearing or procedures against existing law enforcement officers who have had either excessive violence charges or whatever. How much access do the public have to that now? How much access would the public have under the provisions of this measure? And yes, Madam Chairman, I am a diehard defense attorney and a bleeding heart liberal.
Chairman Ellicott, Representative Pelkey, two thoughts with that. I think it's a hard question to answer because it's not spelled out explicitly in the Public Records Act. The discretionary exception says records of investigations, intelligence information, or security procedures. So those are the three categories that are covered under that discretionary exception. Whether disciplinary records would fall under one of those three, it's not clear to me. Where I would go, though, is to the mandatory exception for personnel file. And I think the question that a court would have to answer in terms of, can I request and receive, make a public records request for a disciplinary proceeding or information is whether that's covered as a personnel file, and basically how that would fall. I mean, right now, personnel files are excluded. So if that disciplinary record or process is within that file, it's a question whether that would be able to be disclosed. Otherwise, I'm not aware of another exception in here that specifically says, a disciplinary record for a public employee, law enforcement, otherwise, is expressly exempt. But the real question would be, if it's part of a personnel file, does that exception apply then?
Representative Pelkey, any further follow-up?
Yeah, thank you, Madam Chairman. Yeah, I'm just curious, I mean, obviously those of you who are familiar with Laramie, we've had the issue arise here. And I'm just curious if the public is going to be able to access files on disciplinary procedures that have occurred against a current law enforcement officer or someone who is subject to a current investigation, and how much the public has access to that information. If it's hidden in the personnel file, I'm actually a little concerned. So I just want to get a better grip on what we're dealing with here.
And Chairman Othercott, Representative Pelkey, if I may, the other exception I neglected to mention is the records compiled solely for purposes of investigating violations of and enforcing internal personnel rules. So if there's an investigation held because Officer X violated, Y rule of the department, that seems to be contemplated here. That could be an independent ground for denying that record, without knowing what the record is or is not. It's hard to say, to even offer any sort of measure in terms of how this would apply.
Thank you, Mr. Fuller. Any further questions of Ms. Creech or Mr. Fuller? I think an excellent presentation by both. A lot of work was done here. Thank you. Okay, so with that, I think we will go into public comment. So as we are adding in we will go ahead and start with our State Ombudsman, Ruth Van Mark. Good to see you, Ms. Van Mark. Welcome to the Joint Judiciary Committee. Do you have any public comment you'd like to share with us? Ms. Van Mark? Can everyone else hear me? All right, maybe we will go to someone else and we'll come back to Ms. Van Mark. We have Mr. Bourne from the Casper Star Tribune. Mr. Bourne, if you could introduce yourself to the committee.
Yes, thank you. I am Dale Bourne. I'm publisher emeritus at the Casper Star Tribune, and I'm here today speaking as the the publisher of the Star Tribune, not as a member of any state organization, though I am a member in good standing and support the Wyoming Press Association. I'm here today to speak on my own behalf. Can you hear me?
We can hear you. Thank you.
Okay. Well, thank you for your invitation. I had called some of the members of this committee in May when I saw the memo from the University of Wyoming asking about clarifying some of the public records laws, and had talked about our position and our experience in using public information and public records. And at that time, I had been asked if I would please put together a list of the things that we thought should be included in a personnel file. And there are many items, of course, that I do think belong there. And I had submitted to Mary Ann, I think, the list that I had put together. And hopefully you have that. If not, I can send it along. But that list is things like the Social Security numbers and W-2 forms and medical records and diagnosis. I mean, if a person who is employed by the state is taking a pill for depression, we're not interested in that. We're not interested in dates of birth of their family members and that kind of thing. But beyond those things, the information that we find of interest, depending on what the situation is, oftentimes it's relevant and it's legitimate for us to look at, but we find that organizations will put documents in a personnel file, and then they'll say, well, it's part of the personnel file, so I don't know if I can give that to you. Although I think that's probably why there were so many responses that people were seeking legal advice, because there does need to be a definition of what is in a personnel file. And just putting something in a personnel file doesn't make it or shouldn't make it protected. But I think that oftentimes it does make it confusing. So I do understand that, and I think that if you choose to open up this act, that is worth clarifying. There are a few things that I think that we do need to have as exceptions in the state that are good for us as members of the democracy that are trying to manage our democracy. We need good information, and if we don't have it, we can't make good decisions. And those kinds of things, the things that I'm talking about, I am the person who signed the check for to file a petition to ask a judge to clarify the issues surrounding Lori Nichols. And in that capacity, I came to realize pretty quickly that things were being hidden that because there were personnel questions that there shouldn't have been any question about. I think that the exceptions to the exemptions for the personnel file shouldn't apply to all classes of employees equally. And the leaders of our organizations in the state, such as chiefs of police, city managers, school superintendents, college presidents, and in the case of UW president, have tremendous impact on the people that they serve. And these are folks that we pay with public money on a contract. They're not at will. They're paid on a contract, and sometimes what they do and how they manage and how they behave is really relevant to the public. And I'll give you the example that I think is most recent and most relevant, and that is the issues surrounding Lori Nichols. Most of the students in the state of Wyoming that are educated in our schools, many of the teachers that teach in our schools were educated at the University of Wyoming. And the people who, the students who graduate from our schools, many of them attend the University of Wyoming. And they then become the teachers. They become petroleum engineers or geologists and attorneys and all the various professions that people are educated at University of Wyoming. We're very proud of our UW, and we need them to be successful. If there's cultural events in Wyoming, oftentimes they are associated with the University of Wyoming. If there's money that comes to the state for research in the areas of industry or geology and exploration. Oftentimes, I bet you most of the time, those dollars go to the University of Wyoming. And it's not a stretch to say that I think that the University of Wyoming touches nearly every person in the state, one way or another. We're affected by the University of Wyoming. And the leader at the University of Wyoming is really important to us, every one of us. And I think that we should, as the people of the state of Wyoming, we should get to know what that person does, how they behave. Those things are really relevant to us, and they shouldn't be shielded by, well, is it in the personnel file or isn't it? And what is covered by the personnel file? It would be an important exception to make to those personnel file definitions. I have in the room with me, perfectly social distance, the editor of the Casper Star Tribune, who could probably go into much more detail than you have time for today about our experience with trying to gather information that we believe should be public. But that is the end of my comments, and we would stand for questions. Thank you, Chairman Nethercott.
Thank you, Mr. Bourne. It is wonderful to have you here. We appreciate your time. Committee members' questions. Representative Graves.
Thank you, Madam Chairman. Thanks for coming, Mr. Boren. So I guess my question would be, have you thought about, you did have that list, I think, and write that down, but I'm curious as to what are the limits on this? I mean, you talk about upper level management, you mentioned the university, colleges, a couple other things. I mean, we would need to be specific. So I'd be curious, have you thought about the entirety of that list in your opinion?
Chairman Nethercott and Representative, we have, and I think that outside of the items that are on the list that I supplied to you, oftentimes items that might be relevant to an individual or to us, those items are personal, and they deserve to be aired. If there's a real question, they deserve to be heard in a court of law, to be adjudicated by third parties, because the right of that individual is so important that if they wish to keep that private, it should be heard. But I don't think that they should have the opportunity to just say, well, it's in my personnel file, so it's totally protected, because that can be a ruse, and we have seen that be a ruse many times. And if, with your permission, I would ask if you'd like to hear from the editor of the Star Tribune on that.
Mr. Bourne, I do think that would be helpful. We have a couple other questions, so we'll kind of put those in the stack. And one concept I've been thinking about, wanted to share, and you don't need to respond right now as we come back around to you, but is the difference between those personnel files for those individuals, for those employees that are supervised, as opposed to kind of the class that you have identified of really the figureheads that aren't supervised in a traditional way by a supervisor and a manager. They typically have a board or some other type of city council that is their employer, essentially their direct report. So that might be an interesting concept to think through as we maybe identify some of those solutions for you. Representative Salazar.
Thank you, Madam Chair. So I'm glad you're here, Mr. Bourne. So can you clarify for me, are you supporting or opposing some legislation? Maybe you can just make that clear for me.
I do, Chairman Nethercott and Representative, I'm not here with the bill. I am here because in May, when I saw the memo from University of Wyoming, I wanted to weigh in on it, and understood at that time that there wasn't a bill, that it was going to be a discussion. So I don't have a bill, though I do think that once you open a door like I have here, that you owe it to the people on the committee and the people in my organization and around the state to stay with it until something is done. So if there is legislation, I would like to be included, and you could count on me to stay till the last dance.
Representative Pelkey?
Thank you, Madam Chairman. Good to see you, Dale. I'm curious about, I mean, your focus on your comments was largely on those people who are the heads of large agencies, large expenditures of state fund. Earlier question, what's your position on getting disciplinary records from law enforcement? While they may not be in charge of a multi-million-dollar agency, they travel around our streets, and I'm just curious what the press's position is on trying to get those disciplinary records made public.
Mr. Boren?
Chairman Nethercott and Representative Pelkey, we of course believe that many of those things are, particularly with respect to the police, are of vital interest to the public, not because they're interested because they're fallacious. They're interested because those are the people who have the highest level of control in our society. They carry firearms, they make decisions whether we live or die sometimes. And those folks, as much as, I mean, good on them, I'm glad they're there, but they should not go without some kind of oversight by the public. We should know how they behave also.
Any final questions for Mr. Boren as then we turn to the editor and hear some of those high-level experiences that they'd like to share? All right, seeing none. Mr. Boren, do you want to switch the camera?
Yeah, I do. Chairman Nethercott, may I introduce Joshua Wilson, who is the editor of the Casper Star Tribune.
Welcome, Mr. Wilson. We appreciate having you here.
Thank you. Thanks for having me here. I appreciate that, Madam Chairman. Madam Chairman, I would just speak broadly for a few minutes about the personnel exemption and even broader than that. In my own experience, and I feel like as the editor of the Casper Star Tribune and as the editor of the statewide newspaper, I'm in sort of a unique vantage point in the sense that we interact with where maybe a newspaper editor might in another county might interact with maybe their local community. We interact with public information officers, legal counsel for agencies all over the state, as well as those in Natrona County. And what I've seen, speaking broadly over my 13-year career here at the Casper Star Tribune, is a general move towards less information being released, or put inversely, more aggressively by agencies, more aggressively finding ways to use well-intentioned rules or laws to block the release of information that they might find publicly embarrassing. For example, I mean, the University of Wyoming example, not only with Lori Nichols, but more recently with Sean Blackburn. Both cases, a very compelling public interest of understanding how arguably the most important public institution in the state is governed and how it also investigates matters of concern and matters of leadership. In both cases, the university sought to use the personnel file as an exemption in treating arguably one of the more powerful people in the state with the same sort of protections as someone who might be a clerk, in a secretary, or an office assistant in that person's office. And I would argue that personnel files, the exemptions that are, the comments that are already in the law, were there to protect someone from embarrassing information that the public doesn't need to know about. You know, if the clerk in an office has to take some time off because her daughter has an eating disorder, that's salacious information or prurient information. That's not the kind of information our journalists would be seeking. But too often, those laws that are designed to protect that sort of situation are actually used to block information much more aggressively. And I would say, and I think it's important to add this context, that these same sorts of rules, we're seeing, rules blocking health information. They're well-intentioned rules to protect an individual's health information or educational records. The same sorts of things get applied to the point where, a few years ago, I was told with a straight face that I couldn't, that the, Wyoming Attorney General's office wouldn't release information about whether or not the Department of Family Services was conducting an investigation into sexual assaults at the Juvenile Detention Center here in Casper, which of course there's a big public interest in knowing if that is indeed occurring at a facility. And I was told that merely acknowledging their presence would violate the individual privacy rights of the people within the facility, all of them. And we see this sort of time and time again, the personnel file being an exemption. And I would say one thing to think about is all of the stories that we have broken in the past couple of years where that people should know about, that people don't know about because, or would not have known about if these personnel file exemptions were blocked more aggressively or treated more aggressively. And besides Lori Nichols, we ran into similar sorts of issues related to the morale at the Casper Police Department. Again, an issue of utmost public concern is how is the police department in a city functioning? That was another area. Or, for example, how firefighters responded to a fire that ended up destroying 14 homes that escaped from a public facility. All of those things, I think, are very important matters of public interest that might have been lost if these personnel files were, I guess, if more exemptions were put into place. Finally, I would like to also add that you guys were talking a minute ago about questions about who should be, the power that one might have, or where they would be exempt from public records or not, or personnel files or not. And one thing I would think of is not to think of it necessarily in terms of who they might report to or not, but really over how much power they have over an individual person or the public's life. So, for example, a police officer has the power to deprive someone of their life and liberty. Clearly, they report, they might have 3 or 4 or 5 bosses, but I would argue that they might have as much or more power than a city manager or a fire chief by nature of their job. With those comments, I'd be happy to answer any questions. Thank you.
Thank you. That was very helpful, and I appreciate the pithy nature of it, but very robust and thorough. So thank you very much. As we think about that and hearing those concerns, my initial thought is I think it may be prudent just the way that we tackle it is to distinguish maybe law enforcement officers, because that's a different piece, which I think you're right, that the public importance of those officers who have so much influence in our communities is critical, but it may be easier to start with. Maybe those that are in complete control of their personnel files, right, because they're at the top. To me, it seems easier to do, but I appreciate all the conversation. Further questions? All right, seeing none, thank you. We'll stand by. We may come back around to you. Mr. Bourne, any final comments? Nope. We'll come to Ms. Van Mark. Good to see you waiting. I think your audio is up and operational.
Hopefully it's working now, Madam Chair.
We can hear you, yes. Welcome.
Thank you. I have nothing to add to the excellent work done by LSO on their various briefing memos, but I'm happy to answer any questions that the members may have of me.
Wonderful. Ms. Van Mark, if you would just introduce yourself to the committee, just for our minutes to reflect.
Ruth Van Mark, the Public Records Ombudsman for the state of Wyoming.
Wonderful, thank you. Ms. Van Mark, have you had an opportunity to review kind of the survey results that LSO prepared?
Madam Chair, Yes, I have. And I have to say, just in the last 2 weeks, I've received a couple of calls from county and city entities who are concerned about getting public information requests for citizens' emails that they believe then are going to be used to solicit information from these people or try to sell them products. And so I was very pleased to see that the survey results show that there are other people around the state that have the same concerns, that we need to have something in place to protect individual citizens' email addresses if they have somehow provided them to the city or county for reasons other than to get solicitations from outside vendors.
All right, thank you. Any other comments or observations on some of those survey results? Are they surprising to you or consistent with what you have experienced so far?
I think they're very consistent. If you recall the last meeting that we had, I had brought up the issue of personnel files because I'd ran into a couple of issues. Ironically, one of them being with the citizens' complaints filed against police officers. And the roadblock I ran into in trying to get those documents, if not released by individual for individual officers, at least sort of an aggregate list released for the public to see how many complaints are filed against police officers on a yearly basis. The city decided that those were part of the officer's personnel file and therefore were not eligible for release. So I do believe that is an area that the committee, if they have the inclination to work on, it would be a very good addition to the Public Records Act, if you could clarify that.
Wonderful. Any other thoughts? Looks like we have Representative Washut who might have an interest in this topic. Representative Washut.
Thank you, Madam Chair. Ms. Van Bark, in terms of personnel, disciplinary records and so forth, in the aggregate for like an entire department, of how many complaints are received, what are the nature of those complaints, how many officers were disciplined, without naming the individual employee, is that the type of information that you're referring to, or you're talking about an individual employee having been suspended for so many days?
The first, the constituent who contacted me wanted a list of all the complaints filed against officers in a city in Wyoming over a specified period of time. The initial response I received back from the police department was that that would be part of their personnel file. It would unfairly tarnish the police officers, especially if the complaints weren't proven to be true. And so then we started trying to negotiate a compromise whereby you could just give the citizen who requested an aggregate number of complaints filed on a yearly basis, the type of complaints, but never having the officers' names mentioned, thereby protecting the officer's reputation.
Follow up, Representative.
Thank you, Madam Chair. With the exception of some of our smallest departments, I would think that the aggregate information would not be protected, at least from my vantage point, but that disciplinary records currently are protected under our personnel rules.
Ms. Van Mark?
I believe that was sort of the end result of our conversations back and forth, that given the size of our communities, maybe there isn't a way to provide an aggregate list and protect reputations. However, there is, I believe, a strong interest in letting the public know, is there a issue within our police department where officers are not behaving appropriately? And it seems like the public should have a right to know that. I don't know quite how you go about releasing that information and not disadvantaging any one individual.
Representative Pelkey.
Actually, I may be too early to offer an amendment this time. I'll wait.
Yeah, I don't know that there is a bill draft. So there's no particular bill that the committee is discussing. It's just kind of information to understand what we would want to draft or work on. So,
well, in that case, Madam Chairman, what I'm is that LSO look into drafting an exception to the personnel records provision that would exclude law enforcement officers who've been investigated for excessive force charges to be part of the public record rather than to be protected under personnel records.
Representative Pocket, I look forward to hearing that motion when we complete public comment and kind of hear the whole robust on this, and then we start working the bill.
Like I said, I thought it was a little early on that one.
Representative Potnell.
Thank you, Madam Chair. Yeah, a question to Ms. Van Mark. Has all this questions about police personnel files and things from citizens, or where they're wanting to get into these files on police officers, has this all come about? We've gotten more and more requests since we've seen across the nation defund the police, defund law enforcement officers and the targets against law enforcement. Is that where we're starting to get a lot of these requests are coming in now?
Ms. Van Mark?
Since that took place?
The first request I received was back in the end of February, maybe the beginning of March. So I would say it was prior to the unrest around the country. Certainly since the unrest around the country, I've been contacted by departments who have said they've gotten just blanket requests. In fact, one department called me and said they want to know the race of, they want to know all enforcement actions taken against a citizen by an officer, and they want to know the race of the officer involved and the citizen involved. And then they explained to me, we don't keep that kind of record. So I do believe there is some of that there, and I think I'm understanding where you're coming from. That's a very sensitive issue, and I don't think we want to put our law enforcement under any kind of a disadvantage there. So I would just rely on the wisdom of the committee to come up with the perfect solution on this one.
Thank you so much. Representative Burlingame.
Thank you, Madam Chairwoman. I don't know if this is the exact right place to put this, but I just wanted to remind this committee that we gave the go-ahead to create a data privacy group to study that balance between serving our constitutional rights to access to all public records and not allowing private corporations to monetize our private data. And again, other states who had passed kind of overarching legislation that addressed these and then got sued have fallen back to these task force study group model to look at. It's a new world. How do we address it that best meets that balance?
Thank you, Representative Burlingame. Representative Gray.
Thank you, Madam Chairman. Want to ask Mr. Wolfson the question I asked Mr. Boren, which is, have you thought about the bounds on in terms of personnel file, maybe having more discretion, more ability there for that to be open for certain positions that are higher up management positions? Have you thought about the list to include there in statute, what that list would entail?
Mr. Wolfson?
Madam Chairman, Representative Gray, that's a really interesting question, and I think it's tougher than it might first appear, because the easy solution would just say, well, if you are if you're this high up on the food chain, you're in one bucket, and if you're farther down on the food chain, you're in another. But I think, again, going back to the commentary about law enforcement examples, is that I would. You can make an easy argument, for example, that a police officer, a rank and file police officer, might have more power in a community than an upper administrative officer at the Bureau of Reclamation, for example. Well, Bureau of Reclamation would be federal, but you see my point, is that by the nature of the power that they wield. And so I think it would need to be almost, I think you could probably take a look at that while excluding certain, or I think you'd have to take a separate approach for certain sorts of agencies, law enforcement being one example, because they probably have the greatest powers that a government can have, right? The right to deprive someone of their liberty and of their life. So I think you could probably, if you were to tackle that issue separately, you might be able to do something where you'd say, you know, for example, we'll say upper administration and top administration would fit, but not someone farther down. But I do think, you know, there have to be some sort of caveats based on some positions having kind of disproportionate power by the nature of the job, and we want them to have that disproportionate power. That's not a criticism of that at all, but it's sort of the nature of that situation.
All right, thank you. We have additional public comments, so we'll get to some of those folks here in the waiting room. We have, welcome back, Mr. McLaren from WHAM. Good to see you. And we also have Eric Boley, who cannot get enough of the Judiciary Committee these last 2 days. Mr. Boley, whichever one of you is able to get on first and share your thoughts with us, we'd love to hear them. Mr. McLaren, can you hear me? So we're going to skip to Shannon Anderson.
Hi, Madam Chair, can you hear me okay?
You can, yes.
Okay, great. Hi, everyone. Shannon Anderson with Powder River Basin Resource Council. And you may remember that we wrote the committee a letter about a year ago on this topic. And I just wanted to remind you of that letter because unfortunately, we feel that your interim study is still very constrained in the amount of information that you're receiving, and particularly the bias from the particular agencies that are fielding these requests versus those of us that are actually doing the requests themselves. So we just want you to encourage a careful look at not only the burdens of the Public Records Act, but more importantly, the benefits and why these records are being requested, how they're being used, and really how important they are to the people of Wyoming. And with that, we would encourage in your review to keep the exceptions and exemptions narrow, as the courts have instructed that they are. The courts have consistently affirmed the public purpose of disclosure and transparency through their interpretation of the Public Records Act. And that purpose has underpinnings in the First Amendment that should always be front and center in your discussions. But that purpose is always important, but given the fiscal challenges of the state, we believe that transparency discussions are really critical at this particular time in Wyoming. We would encourage you to think about the extensive case law, both state and federal, given that a lot of the exemptions are mirrored in the Federal Freedom of Information Act. And it's not clear cut. It never will be. The judicial tests are always meant to be applied case by case. So we would just encourage you to kind of take a step back and understand that if your goal is statutory certainty on any of these exemptions, that's not a realistic goal. That's not how it's meant to be applied. And that's not what agencies can seek. It really is meant to be, you take a request, you submit it to an agency, that agency looks at that request, they fulfill it, they produce a set of documents, and they review those documents, they withhold the ones that are necessary. And every single one of those situations is going to be different. So you have a set of exemptions, you have standards and tests set up in case law, but again, it's impossible to achieve statutory certainty on how any of these exemptions can be applied at that level. So what is a better approach is, I think, what a lot of the agencies were getting at in the survey, and I think Ms. Craven has some additional information for you on this as well, which is really training and resources and other abilities and other ways that I think the agencies.
Better yet, you need
Representative Pelkey, could you make sure your mic is muted? Thank you. Excuse me, Ms. Anderson.
Oh, no problem. Thank you, Madam Chair. So training and resources, I think, would be helpful for agencies. And in our letter last year, we also mentioned technology as a really important tool for agencies and the government to help respond to these requests. And we would encourage this committee to think about technology, resources, training, and kind of that end versus maybe the law itself, but really what are the tools that agencies need to comply with the law. So that's our overall comments. And again, we just wanted to re-emphasize and maybe refocus a little bit about where the committee is headed. And I'd be happy to answer any questions about our experience with the Public Records Act and requests that we've done and litigation that we've done as an organization.
Thank you, Ms. Anderson. Representative Gray.
Thank you, Madam Chairman. Ms. Anderson, so I do understand your point on the survey. I think they did a good job, but it is methodologically towards the requestee, not the requestor. And so, I mean, I agree with you there, but I want to make sure, I mean, our discussion so far today has been on the personnel file, which is a blanket mandatory exemption. They can't provide anything in the personnel file. And we've heard testimony that, well, they're just placing things in the personnel file, it shouldn't be there, and saying that's not a public record. And we're talking about going into that. And to me, that's towards the transparency end. So I want to make sure, I understand there's a lot of nervousness with groups whenever the Public Records Act gets open, but I want to make sure, I mean, you're not necessarily, are you to the point where you're nervous that we might go down a bad path if we open that up, even though it's a mandatory exemption where it's nothing once it's in the personnel file? Or were you just talking about the survey and sort of that approach?
Yeah, Madam Chair and Representative Gray, it was more just general comment on the personnel exemption itself. I think you've received some good testimony today that can probably guide you if you do want to open that up. Again, I would caution the committee that if you do open anything up, to really kind of keep the overall goal of transparency and public disclosure in mind, because that is the goal. So thank you.
Representative Stith.
Madam Chairman, thank you. Ms. Anderson, I had a question for Ms. Anderson, whether the Powder River Basin Resource Council had an opinion about bulk requests to the Department of Environmental Quality, which many of which are by commercial entities that want to harvest the government data and then resell it. And then there's the public interest aspect too. Does the Powder River Basin Resource Council have a position on whether there should be any different standard or higher fees for production of, tens of thousands or hundreds of thousands of documents from a single agency?
Yeah, Madam Chair, Representative Stith, I think that's a great question. As it stands right now, as you know, there is not a need to show why you're receiving the information, or anybody can request records in the state of Wyoming equally, and agencies respond to those requests equally. We have, as an organization, we have advocated for fee waivers for public interest requesters versus commercial requesters. And we really do believe the voluminous issue was addressed through the fee rule. That was what it was designed to do. But with that, it's also harmed public interest requesters that have a legitimate public interest in the information. But to date, actually, we have yet to pay a single dollar to the DEQ for any of our requests. So, so far it's working pretty well, I would say.
Any follow-up, Representative Stith? All right, thank you. All right, we'll go on to the next public comment. Mr. Farmer, I see you're ready.
Thank you, Madam Chair. Brian Farmer, Wyoming School Boards Association. First want to thank the committee. Your patience and endurance are to be commended. There's probably a dozen things I'd love to talk about public records, but I'll really keep it very, very brief. If you are considering future bills, One thing that I would like to ask you to consider is the challenge of when the record is held by dual custodians. So a perfect example of that is recently the state superintendent was asked for information about school district teachers, salary information. And the state collects a massive amount of information about education and education finance. In some instances, and they're very rare, but there are instances where there may be a need to withhold that information because of safety and security concerns. Instances of domestic violence are the ones that come to mind. I can tell you that that's not hypothetical, that's real. That's something that I've experienced in my work with school districts. And certainly something where there are those exceptions. But that's the kind of information that only the employing agency would have. And so when there is a dually held record, my thought is that, excuse me, release should be by the employing agency. So in other words, the school district would release the information as opposed to the state superintendent, because the school district would be the one that would have the information relevant to whether or not that is sensitive information, or if the requester had requested that it be kept private, something along the lines with the Utah language that you looked at in your memo. We do have something like that in Wyoming statute now, but again, only the employing agency would have that. Very small comments. Representative Gray had asked about the exception for presidents of institutions of higher education. The legislative history on that does go back to the chilling effect that it would have on applications. And I can tell you that that does not only apply to institutions of higher education. There is a teacher shortage in the United States, which has led to a school administrator shortage in the United States, which has led to a superintendent shortage in the United States. It is hard to get people to apply for positions in Wyoming. We have 10 new superintendents in Wyoming this year. And it is difficult to fill those positions. Sometimes it is chilling for outside applicants, somebody who is currently in a position in another district that applies for the position. They may feel threatened in their current job if they apply for another job in a Wyoming district. So small information. I'm not requesting that you change that, just that you think about that. Final comment has to do with the survey. And I would hope that the survey results are not terribly surprising to the committee. We did have a coalition of local government entities that have worked on this issue of public records over the last year or two. And one of the things that we've talked about over that time is the need for training, the need for guidance, the need for uniformity. And so that you hear that in the survey really is a reflection of something I think that we've previously said. Madam Chairman, I thank you for the opportunity to comment, and I thank you for the work of the committee.
Thank you, Mr. Farmer. Appreciate hearing from you. Questions from Mr. Farmer? Representative Washit?
Thank you, Madam Chair. Mr. Farmer, do school districts routinely release the disciplinary records of school teachers and school bus drivers? Mr.
Farmer?
Thank you, Madam Chairman. The answer to that question is that it would be done on a case-by-case basis. It would be done on consultation with legal counsel. And so there, I don't think, is a routine practice because you have 48 separate school districts, many different instances. Perhaps the areas or issues where those come most to light might be those allegations of sexual misconduct against employees of a school district. And generally that information is protected under the personnel file.
All right, further questions for Mr. Farmer? All right, seeing none, we're going to go to the next in public comment. I think we have Mr. Downing and Council Ms. Craven. Welcome, Mr. Downing. If you'd introduce yourself to the committee.
Good afternoon, members of the committee. Am I coming through okay?
You are, yes.
Thank you, Chairman Nethercott. This is Jonathan Downing testifying on behalf of the Wyoming Press Association. I want to thank the committee for taking the time to continue their work on this issue and all the work that they've done over the years. We do appreciate the work that's been covered there between public records and public meetings. For the association, we are currently opposed to new exemptions and don't desire to change the existing statute currently in a manner where you might see the recent changes that have been put in statute the last few years get watered down. We are wanting to have a balanced approach to this process, and we do appreciate the work that's been done there. I think you will hear some testimony later on about a desire to try and get the stakeholders, whether it's the producers of public records as far as local and state governments, special districts, working together with the Wyoming entities as far as the consumers when you're looking at the citizens and you're looking at newspapers and so on down the line. And so as far as some of those areas and looking over that survey, that's where we heard some interesting perspectives from the committee. We did appreciate the comments from the ombudsman. As we might get some questions later on regarding personnel files, as far as the discussion that had just come up earlier, at the association level, as you see with many other associations, we would need to see a bill before I think you would see the association take a position on the bill. And you also have the cost bill there that there had been some work done last year to try and clarify some things where the association had worked with the senator on that end. And so just in summary, as far as where the association is, we want to be an asset to the committee and provide a balanced approach. We also would obviously be opposing if there were things to water down or create less openness, less access within the law. And with that, I'd be open for any questions.
Thank you, Mr. Downing. We are limiting our work in this interim to looking at just the exceptions and then generally the Open Meeting Act. I'm not aware of any legislative action or participation by your folks that dealt with exceptions before. So maybe enlighten me on what you're concerned about being watered down.
Thank you, Madam Chair. And so during some of the discussion at the prior committee meeting, there had been some areas where the University of Wyoming had talked about possibly trying to get some further clarification in there. And right now the concern, and we have a broad membership of some that would say, hey, let's do more, let's do less. And so what we're liking to do there is to try and stick with the status quo. But there were some comments made about possibly trying to get some more exemptions into the law on that end as far as the 6 points that have been raised there.
Mr. Downing,
and that was just carry up from the last meeting though.
All right. Thank you. Ms. Craven?
Thank you, Madam Chairwoman. Can you hear me okay? Wonderful. Members of the committee, Madam Chairwoman, thank you for allowing me to testify. I submitted some written comments about 3 pages in length with several attachments. I think that it's an important note that when we talk about exceptions, and I read the well done survey and appreciate all those remarks being given to us because it is very insightful. And when we think of that kind of retrospectively, I think we can see that the problem isn't needing more exceptions or even clarifying the exceptions in the law necessarily. I think a lot of the problem comes from several local governments in particular that are severely understaffed, some large requests coming in, and a lack of understanding about what these mean and how they can be in compliance. And when we originally discussed the role of the ombudsman before it was legislated, that was one of the main goals, was we needed a facilitator. We needed someone to really step up and be an integral part of that communication to avoid these hefty costs of litigation. And so what I've proposed in my written comments and what I'll reiterate very briefly here is I think it would be of great benefit to have some sort of working group that could really involve all of the stakeholders to gain a better understanding of where the muddy areas really are And also perhaps consider some training opportunities specifically with relation to the exceptions and the exemptions that we already have on the books. And I wasn't very familiar with this until I did the research, which is why I provided those to the committee as well. But I have recently learned that several states, most states, in fact, require training, a certain amount of hours and certification, and they even have persons in, Ms. Van Mark's position, for example, and several other county clerks, perhaps, or people in those roles that can go travel the state and do trainings abroad, can do them via Zoom. And I think that would be something that would be very beneficial. But to garner, what areas we really need to focus on, I think a working group would be very valuable for this committee to consider to that end. With regard to some of the previous things that were testified to today, and I failed to introduce myself, I apologize. Cassie Craven on behalf of the Wyoming Liberty Group. And we would be in support, however, of a clarification of the personnel file rules. Similar to what Mr. Downing said, it's hard to really take a position until we see that bill. However, I think when you look at what's been litigated in this state, that particular exception has been subject to a lot of very expensive fights. And so it might be worthwhile to head some of those off at the pass, if you will, and be very specific about things that might be out of the province of the personnel file. So we would be in support of the committee furthering that work. With regard also to something that Mr. Downing mentioned, we too are in favor of a balanced approach. In my review of looking at these other states and why they require the trainings, a lot of their websites will be very detailed that they consider it their duty to provide these records to the citizens. And I think for far too long in Wyoming, we've made this a very adversarial process and something that it seems like a heavy burden. In fact, I remember previous testimony just a couple meetings ago where the list of exceptions that were being proposed was qualified as a Christmas list. And I think while that, seems offensive up front, I can understand why it is troubling and very hard for employees to have to keep up with these things. But that's where I come back to bringing all the stakeholders to the table and really coming up with some valuable solutions. So with that, I'll keep it brief. I know the committee's had a very long day, but I'd happily stand for any questions.
Representative Salazar.
Thank you, Madam Chair. Just a comment. I want to thank Ms. Craven. I highly respect your legal expertise, and I appreciate it when you do come to the judiciary to give your viewpoints. And I know some others do as well. So thank you for appearing today.
Madam Any questions for Mr. Downing, Ms. Craven? All right, seeing none. Thank you both for being here. We appreciate all your work and your contributions to the committee. All right, I don't believe that there's any further public comment. So committee members, is there any final questions that you want to ask to any members of the public that we've heard from today? All right, with that, public comment is closed. Okay, committee members, there's not a bill draft in front of you, but I think a lot of good discussion for the state moving forward. I know I feel a little confused by hearing two different pieces of information of don't do anything, don't touch anything, and then we're okay with a couple of pieces. So I'll take that into consideration and I'm curious to hear your thoughts. Representative Gray?
Yep, thank you, Madam Chairman. So I'd like to bring a motion to prepare for the LSO to prepare a bill draft to clarify the personnel file exemption and to provide a bifurcation where certain levels of personnel, there is more that is available to the public as a public record, and would ask, so we can get that wording right, I don't think we can do that today, that we create a working group focused mostly on that, but also a little bit broader, engaging with the public a little more on the stakeholders, non-governmental organizations, on anything else they see, but focus the working group mostly on that personnel file wording.
We have a motion from Representative Gray, seconded by Representative Jennings. So I heard two things, and I'm not quite certain what you're asking. So you want a bill draft, but also a working group. And so do you want LSO to what do you want them to do as opposed to the working group's work?
Madam Chairman, can I go ahead?
Yeah, please. Yes.
Thank you, Madam Chairman. Yeah, I think the committee has to authorize LSO to prepare the bill draft, but I'm saying that the subcommittee would have to provide direction about what really is in it, which is that definition of what is going to be the bifurcated class that would be more open. Their personnel file would be more open. And I don't think we can list those off here on August 21st. I just don't think there's too many. I think the supervisory language is complex. I think we have to sit down and really think about, frankly, whether it's possible. I think it is, but that would be my motion. Somebody can amend it if they think we can be a little more specific this time, but.
Representative, so we're on discussion on the motion. Representative Pelkey.
I'm in support of the motion, and I'm not sure we need specific language given Representative Gray's suggestion, but I'm a big advocate of making sure that investigations into excessive use of force involving law enforcement officers is part of that issue.
Okay, so is that a friendly amendment, Representative Gray?
Madam Chair, in my opinion, it's sort of just I don't think it's really an amendment. I mean, I think it's within the original motion, which is
okay.
we're gonna provide a clarification on what the personnel file is open, and I think that's what Representative Pelkey was saying, that he's interested in that. And I don't think he meant to amend my motion, frankly. You can clarify that, Representative Pelkey.
No, this is one of the rare instances where Representative Gray and I are in agreement. I think this is one of those issues that needs to be explored in depth. I'm simply for the issue, but I want the record to show that I wanted a broad look at what exemptions we have.
Okay, great. So further discussion. I think maybe LSO, I'm sure we'll hear from them, are unclear on what to do, but we will let them speak for themselves. So committee members, further discussion? Mr. Fuller?
No, I was just going to say, Chairman Nethercott, I understand that there will be, there's a motion for a bill draft that will be provided by a working group to be appointed depending on the results of the motion.
Thank you, Mr. Fuller. Representative Washut?
Thank you, Madam Chair. I think as a starting point, I've taken a moment looking at a few of these human resources websites that had lists of the types of things that belong in a personnel file and things that don't belong in a personnel file, and maybe creating a list of some of those more commonly listed items in personnel files. And then, we can debate whether to keep or add to that list as we talk about the exemption for a personnel file.
Representative Stith.
Madam Chairman, thank you. I just have a question for clarification from Representative Gray on this motion. What it means if I vote yes, because I'm in favor of looking at the definition of personnel files and maybe having different tiers, I'm not in favor of busting open every police officer's personnel files. So if I'm voting yes, am I voting to say that I believe that every police officer should have their personnel file be subject to public scrutiny? Then I would be voting no if that's what this motion means.
Representative Gray.
Madam Chairman, my intention was to focus on classes in the personnel file and not to focus on specific occupations. Now, certain classes in the personnel file could fold in certain occupations, but I think, Representative Pelkey's very interested in that, and he's always had that interest. And I come from a little bit of a different angle, but I understand where he comes from. And I understand the concern. I'm concerned about the direction of our country and the unrest here that we've seen the last few months and the tone of that. If you want to try to amend my motion, I think it's vaguer. I don't necessarily think it's specifically focused on that issue.
Representative Pelkey.
And again, I'm not looking at delving into every aspect of law enforcement officers' personnel file, but the one issue that I wouldn't mind bringing up, and if I was able to be appointed to the working group, is simply to raise the issue of involving excessive violence or death of a citizen, and trying to not protecting those records simply because they would be part of personnel file. Again, I've heard that mentioned repeatedly this afternoon. Is we talk about high-level executives in certain agencies, but when it comes down to the citizens of this state, the people who have power of life and death are often the guy driving around in a police car with a gun and I'd just like to get a clarification that we can access those records as part of the public record and look at those and let the public examine those as well.
Senator Boner.
Okay, thank you, Madam Chairman. My space bar wasn't working for some reason. Yeah, just on support of the motion, just obviously if we need a bill draft to move forward, we can discuss any amendments we have to whatever the working group comes up with. I'm very much in agreement with Representative Stiff. I'm going to be very skeptical of anything that's going to make it more challenging for law enforcement officers to do their job. But that's something we can discuss once we get the bill draft at the next meeting. So I'd hate for any potential concern about what may or may not be included to prevent us from moving forward. We can have that discussion once we have a bill in front of us, and obviously we will, I imagine, be a robust conversation. But I hate to get wrapped around that axle right now when we're just discussing whether we're going to get the bill draft going.
Representative Pannell.
Thank you, Madam Chair. Yeah, it does kind of concern me that we're just going to open a book for personnel files on police officers. Because from what I can understand, they're going to just do a blanket deal if there's any accusations of abuse or anything from an officer. They'll want that be released, even though the officer is legitimately innocent of it. So I think that we're kind of staring down the wrong direction. And I don't know, to be honest, I don't know of a real issue in the state of Wyoming that there is a problem with this. If there are, officers that do violate the law or have serious incidents take place, they're pretty much, it's an open book to them when if they're charged criminally or anything. So I just think that there's not a need in this. And I think from the testimony we heard earlier is that we better be a little careful on this personnel file, opening it up to more latitude, even through the school districts, through different businesses, higher education or whatever. I think that, we're going through a time period where we're wanting to draw business into this state. And if we're going to start looking at a lot of, civil issues to open up personnel files and all these different entities, I think we're going down the wrong plate. So thank you.
Representative Pannell, I share your concern. And when I look at the definition of personnel file in the other states based on the memo from LSO, I don't see a lot of differences between our own. And I do think some of the testimony we heard today is that some of these definitions are kind of naturally undefinable, and there is some ambiguity to them. And so there's a strong desire to try to provide more specification, particularly to the government entities who responded to the survey, but I'm not sure that that's really achievable when we look at what the other states have done and defined personnel records. So I think there might be wisdom in doing nothing at all, but reviewing the issue and leaving some of those. It seems to be what everyone is comfortable with generally, despite acknowledging that personnel record is kind of a squishy definition. So Representative Washut.
Thank you, Madam Chair. Just going back to Representative Stiff's comment, can we get a careful phrasing of what exactly this motion is that we're voting on?
Representative Gray, I think your hand is up, and I think that question's back to you.
Thank you, Madam Chairman. The motion is to direct the LSO to draft a bill to clarify the personnel file. One, what is in it and what is not. And number two, are there classes within the personnel file that more should be open versus less? Now, I kept that broad as to what occupations we're gonna talk about on that. And I understand the concern. I'm very pro law enforcement, okay? And I think this is kind of getting down there's one area where we're talking about, and I understand a lot of people concerned about that, but I think if we're going to create a working group, that's the second part of the motion, and we're going to create a working group to clarify those two issues, because I don't think we can do that here on a Friday at 4:43. I don't think we're going to be able to do that because there's going to be some tough questions there. And we create a working group to clarify those two questions. And to me, I mean, I think we approach it a little more broader, vigorous, try to come up with a bill, do our best by October, and it can get accepted or rejected. To me, though, we got to be honest. If this is not an approach that is acceptable, I think then this issue is something that our committee's decided that we don't think we can really address. And maybe that is the conclusion of the committee, but that's my motion.
Okay, further discussion from the committee? All right, sensing you're ready for the question, on Representative Gray's motion, please raise your hands. All those in favor, raise your hands. Aye. 1, 2, 3, 4, 5, 6, 7, 8, 9. All those opposed? Three opposed. That motion has passed. There is no identification of the working group, so let's probably get that figured out right now. We have a meeting October 31st, Halloween, which is in a couple months. So volunteers for this working group that will provide the information to LSO. Representative Pelkey is first on the list. Representative Gray, of course. Lots of support for the motion, no support for the working group. I have a feeling that a lobbying organization will be drafting this for us, and such it shall be.
Madam Chairman, I would nominate Representative Washut to this working group.
I'd agree.
I just remind the committee I voted against this bill.
That's why.
Actually, Madam Chairman, Representative Washut, an ideal member of the working group, given the fact that he and I have perhaps diametrically opposed positions on some issues, and I think he brings a lot to the table. So I truly ask you as a favor, sir, if you would agree to join that.
How could one say no? Representative Washut, you are now on the working group. Lovely. Okay, everyone, let's move on with the agenda. Co-Chairman Kirkbride.
Thank you, Madam Co-Chairman. I would like to pick up on Mr. Farmer's discussion about when there are dual repositories of information and one feels obligated to divulge information that might damage another. as was the case with the Department of Education and the local school districts. I don't know if that's a standalone incident of that, or if that principle comes into play in other agencies and other local government situations, but I'd like to deal with it and see what the rest of you think in terms of whether it's in itself a bill or is there a broader issue there.
Mr. Co-Chairman, I think that's a great, I was good not to forget that issue. And I think it is a broader issue in the sharing of information that occurs and that we desire to occur between different agencies. I think it occurs most often, probably, at least within education, where you have students transferring from different schools and then ultimately held within the Department of Education. I can't think of other agencies, courts maybe as well, but so I do think it would be prudent and easy for us to manage that, in that the originator, the originator of the document, of the file, is the agency that makes a determination about its disclosure. Thoughts about that? Seeing a lot of these. I mean, it seems to be easier for them to handle that if they know who is responsible, and if you're the requester, who you send the request to whom you send the request to, and then who is responsible, who you sue if you have to, who do you go to the ombudsman with if you want to. That seems to be a good solution. So Co-Chairman Kirkbride, do you want to make a motion?
Well, I'd move that LSO prepare a bill that directs the requester of the information to the original source and obligates them to do that.
And that is seconded by Senator Cost. Discussion? Representative Gray?
Yeah, thank you, Madam Chairman. I'm going to vote no on this. I understand the situation is addressing, but I just think having that dynamic element, I mean, I like what played out last year. I think that's fine. So I'm going to vote no. Thanks.
All right. Susan, you're ready for the question. All those in favor, raise your hand. 1, 2, 3, 4, 5, 6, 7, 8. 8. All those opposed? 1, 2, 3, 4, 5. That motion has passed. Okay, any further thoughts or comments on the public records? I tried to get this put on the agenda not at the very end of the day, on the second day, which is where it always seems to go. And I felt like that's been a disservice for us on the topic, but it is how the schedule had to be. But I do think it has had a negative impact for us and our ability to work it through. All right, our next item on the agenda is LSO Working Draft 70, version 3, Public Meetings Executive Sessions for Security Planning. And I guess we have the Public Meetings Act. So before we get to that, Senator Cost, I just wanted to scare you for a minute, get your heart pounding. We'll have Mr. Fuller go through the Open Meetings Act.
Yeah, Chairman Endicott, members of the committee. I'll just start with, kind of the broad strokes. The purpose of the Public Meetings Act is to ensure that deliberations and actions are taken openly, that open decision making is the touchstone of what is required. The Public Meetings Act applies to all agencies of Wyoming except for the state legislature, the Judiciary, CREG, and the Investment Funds Committee. Those two entities are specifically excluded as being covered. An individual alone is not the governing body. It's the group that has ultimate control and responsibility for making decisions and taking actions is the entity to whom the provisions of this act apply. Generally, all meetings of a governing body are public meetings and open to the public at all times, except as otherwise provided, namely those instances where a governing body is entitled or is able to go into executive session, or when there's not a quorum present. So a meeting is an assembly of at least a quorum of the governing body of an agency that has been called for the express purpose of discussion, deliberation, or taking action regarding public business. The Supreme Court has noted a preliminary gathering where nothing is done is not a meeting for purposes of the Act. In terms of actions that can be taken, a governing body cannot take any action or transact official business except during a public meeting following notice of that meeting. An action that is taken at a meeting that doesn't comply with the provisions of the Public Meetings Act is null and void, not simply voidable, it's basically void ab initio, void from the start. In terms of notice for meetings, if there's no statutory requirement that a governing body must provide by ordinance or resolution, notice the procedure for notice of public meetings and adhere to that notice requirement. If for example, a board or commission does not have regular meetings at a normal or regularly scheduled intervals, that entity must provide notice of the next meeting to anyone who requests that notice. If a meeting is considered a special meeting, one that's not normally held, notice must be given to each member of the governing body and each newspaper or radio outlet or television station that requests a notice. For emergency meetings, those can be held for matters of, the term is serious immediate concern, to take temporary action, and that can be done without notice. But the governing body must still make reasonable efforts to offer that public notice. Any action taken at an emergency meeting is of a temporary nature and must be reconsidered and acted upon at an open public meeting within 48 hours of that emergency meeting. If the emergency still persists or continues to exist, then the governing body has up to 30 days to reconsider and act upon the temporary action at a regular meeting. In terms of just daily administration of a governing body, daily activities that a governing body may hold are not subject to the notice requirements or meeting notice. For minutes of a meeting, those must be recorded, but do not have to be published unless action is taken. If no action is taken at the meeting, the Act provides that those minutes do not have to be published. A member of the public who attends a public meeting isn't required to give his name or affiliation or supply any information or meet any condition to attend, except that in order to speak or be recognized at a meeting, that person may be required by the governing body to give his name and affiliation. In terms of executive sessions, the Public Meetings Act gives a list of reasons that a governing body may enter into executive session. Those are included in that memo that had the information about the Public Records and Public Meetings Act. I can list through them or just refer you to those. Generally speaking, in terms of executive sessions, a governing body must keep minutes during the executive session, but they remain confidential and are only produced upon a validly issued court order. Minutes must be in sufficient detail of the confidential information that was discussed, except that parts of minutes for executive session that reflects an objection are not confidential. Governing body can hold executive session after a motion and a second and passed by a majority of the members in attendance in order for that governing body to enter executive session. Just to wrap up other matters that's covered in the Act, a governing body can remove a person or a group that willfully disrupts a meeting. The governing body can recess and reconvene in a different location, but if it does so, it can only act on the items that were specified in an agenda that was part of the meeting notice. The media shall be allowed to attend any meeting unless they participate in a disturbance that results in that willful disruption. Any member of an agency or governing body that knowingly or intentionally violates the Public Meetings Act is liable for a civil penalty. A member who attends or remains at a meeting knowing that the meeting violates the Act is liable unless there are minutes taken or an objection noted that shows where the member has objected to the process of the meeting or entering into executive session or an action taken. And then finally, there's a provision that notes that if an action is prohibited in the criminal code, that takes precedence over the Public Meetings Act. And then finally, an agency can cure a void action by conducting a new and substantial reconsideration of the action in a manner that complies with the Public Meetings Act. That's, members of the committee, a very quick and broad overview of the Public Meetings Act. I'm happy to answer any questions.
Thank you, Mr. Fuller. Any questions of Mr. Fuller? All right, seeing none. Excellent job, Mr. Fuller. Public comment on this. I think we have Mr. Farmer. Oops, I think I hit the wrong button. I tried to remove him, sorry. Good thing we have Mary Beth. Mr. Farmer, if you're available, go ahead and reintroduce yourself to the committee, and we're happy to hear your thoughts on open meetings.
Thank you, Madam Chair. Brian Farmer, Wyoming School Boards Association. Thoughts on open meetings? Boy, they're a lot of fun, aren't they? We all have been learning an awful lot about open meetings during the pandemic. I think our local governments have endeavored to still become accessible to the public during this time. And as a matter of fact, I think most local governments have innovated during this time. I think you will see some things that will persist after the pandemic. We still have some entities in Wyoming that are meeting remotely due to their conditions. Some of the school boards on the reservation right now are still conducting their meetings in that format. But I think one of the really great things that's happened is we've all learned about things like YouTube and Facebook Live and how to share our information and our meetings with the public over time. Kudos to the legislature for pioneering the way on that. Thank you for what you've done. I can say my experience is certainly not limited to Wyoming. I chair my national organization, and so I have the opportunity to see what happens across our country. And I think Wyoming is doing it as well. And I think our Wyoming legislature is doing it better than most across the nation. So again, kudos to you. I do want to speak specifically to the bill that you will be seeing shortly from Senator Cost. Perhaps you've already seen it. There's that little bit of lag between being admitted to the meeting and what I do watch on YouTube. But we are supportive of that. We've certainly asked for that, talked about the concept before. When it comes to executive session, we do try to limit those instances. Most of the time, a school district will only go into executive session to consider personnel matters, to consider legal advice, to consider student discipline, sometimes purchase of property. But safety is certainly an issue where the law today does provide us an avenue to talk about it. But if you read Wyoming statute, it almost depends on who's in the room. So a clarification that we can provide for discussions about school safety and security when there is a threat to life or property certainly would be helpful. Those are things that we would not want bad actors to necessarily know about, and would like the opportunity to have those conversations in executive session. A reminder that any action still has to occur in the public session. So if there is adoption of something, or there is some action, that still has to happen in public session. So this is not hiding from the public. This is just keeping confidential those matters that must remain confidential to protect the safety and welfare of individuals, and then returning to public session for deliberation. With that, Madam Chair, I will try to stop talking and answer any questions you may have.
Mr. Farmer, thank you. Any questions from Mr. Farmer? Mr. Farmer, I know that the executive session, and you just identified it, one of the bases to go into executive session is to discuss the purchase of property and it's limited, I think, to real property, so only the purchase of land, when the public discussion of that might influence the price of the land. Do you think that it would be smart to broaden that to be any kind of purchase that a government entity might be interested in making, that they're able to have those discussions confidentially, but any action, as you indicated, be public for the same purposes of protecting taxpayers' dollars and eliminating rigging the price potentially?
Madam Chair, I appreciate the question. I will say my experience on an elected board is only about 10 years long. I have an additional 7 years in this role working with others around the state, and I don't think I've heard of an instance where that's been talked about, where that's been desirable for the purchase of goods or services for the protection of safety. So I don't know that I've heard that there's a need for that, but I certainly would like to explore the idea if there were a further discussion. I will tell you, being a member of a school board that has purchased property, price goes up the more the public becomes aware of that property. And as we try to be good stewards of the public resource, our effort really is to keep that at a fair market value, as reasonable of a price as possible when purchasing land. So that's why we go into executive session for the purchase of real property. I'm not aware of an instance where it's been talked about otherwise.
All right, thank you, Mr. Farmer. All right, seeing no further questions from the committee to Mr. Farmer. Oh, Representative Pelkey.
Yeah, I just want to get a definition of real property. Does that solely include service rights, or as in the recent Occidental issue, would real property include mineral rights as well?
Hey, Representative Pelkey, I think the statute just says real property. So I would assume that it would, but I don't know. So, all right, moving on. It looks like we have Mr. Merrill here as well. Welcome, Mr. Merrill.
Thank you, Madam Chairwoman. And thanks for the opportunity to testify today. I'm Chris Merrill, Executive Director of the Equality State Policy Center. So the proposed change to the public meetings law before you today seems reasonable, and it makes sense to my organization for the reasons that Mr. Farmer just cited, and he covered very well. And as the committee reviews the public meetings law, and especially since you're looking specifically at section 16.405 today, I'd ask you to consider amending this portion of the law further. And before I tell you what that consists of, if one were concerned that such a proposed change might jeopardize the success of this current bill, then I just ask you to consider this amendment in a separate standalone bill. And that would be to require audio recordings of executive sessions. So that, the recording of executive sessions is not a new concept. Of course, Colorado, for example, has this requirement in state statute. And I think it's worthy of this committee's consideration as you continue the process here of reviewing this law. So under current law, executive sessions can be called for the list of specified reasons discussed earlier. But if a citizen has information or receives a tip that indicates an illegal closed session might have taken place, even if it's true, it can be incredibly difficult, if not impossible sometimes, to establish that in a court of law. So the law currently relies on individual members of a governing body to report to the public if an illegal session has taken place. From my perspective, this is less than ideal because, for one thing, members of the public board might not even be aware about whether a topic is or isn't appropriate for an executive session as defined by the law. And also, just culturally, as social animals and sometimes as political animals, many people are uncomfortable and very reluctant to call out fellow board members in the way that the law envisions, I'd argue. If if boards were required to record their executive sessions, then a citizen had reason to believe an improper illegal executive session had taken place, he or she could then petition the court, and a judge could review the recording in camera to determine if the executive session were legal. But to me, and probably the more important outcome would be that the simple act of recording the executive sessions with board members cognizant of the fact that they're being recorded would help lead to better awareness about what is and what is not appropriate to discuss in executive sessions, and should lead to better adherence to the law in general without the need for litigation. So a bill that would have accomplished this very thing, HB 120, passed in the House in 2011, and it failed on third reading in the Senate. So example language already exists, and Colorado state statute also provides excellent example language, in my opinion. So thank you for considering this concept and for the opportunity to speak today. And with that, I would be happy to try to answer any questions.
Thank you, Mr. Merrill. Looks like we do have some questions. Representative Washut.
Thank you, Madam Chair. Just very quickly, Mr. Merrill, my concern with audio or video recording these executive sessions are the sometimes delicate topics that are being discussed, and I think you have a real chilling effect on the conversation if it's being recorded. Yeah, I hope you see what I'm saying. I think there's a fear that sometimes maybe recordings will get out, whether authorized or not, and I just can't imagine folks being comfortable talking about some of these topics when we're recording them.
Madam Chairman.
Mr. Merrill.
Yeah, I mean, I'm certainly willing to accept the premise that might be the case, and there might be trade-offs in making this switch. But I think the trade-offs on balance would benefit the public and public access and transparency. And so I guess that's where I'm coming from. But certainly it would change behavior.
Co-Chairman Kirkbride.
Thank you, Madam Co-Chairman. Mr. Merrill, in the bill that you referenced, the 2011 bill, is there an archival consideration? Are these recordings saved for posterity, or are they just saved for 1 year? How does that work?
Mr. Merrill.
Mr. Co-Chair, I do not recall that. I'm looking at it right now. I don't know that it got into specifics about duration. I don't think it did. It was a very short bill, and I'm looking at it. I do not see anything in there that specifies the duration that it would need to be archived.
Representative Pelkey, is your hand still raised? Representative Salazar.
Thank you, Madam Chair. I tend to favor, Mr. Merrill, what you are recommending. I remember a former president of the United States before the Supreme Court who wanted to keep those tapes because it would stifle executive privilege. It would dissuade people from having frank conversations. But I think you would agree with me, you're not advocating that these be made public unless there was some specific evidence that they had gone outside the reasons for being an executive session. So it's not like these videos or audio tapes would just randomly be handed out because someone requested it. I'm assuming that you're making the argument that it would only serve as a record if in fact there was something that needed to be investigated. Thank you.
Madam Chairman, Representative Salazar, that's exactly what I'm saying. They would be confidential, but if a judge determined that a discussion that was had or a decision was made in executive session and it wasn't in compliance with the law, then that information would be released to the public.
All right, further questions, Representative Washit? Representative Gray? Representative Gray?
Yep. Thank you, Madam Chairman. Mr. Merrill, I wasn't at the Corporations Committee meeting during the session where it appears it failed on a 4-4 vote. So what was the legislative history on that? It seemed pretty divided. So what were the debating points in that meeting?
Mr. Merrill?
Madam Chairwoman, I do not know. I don't think I was there.
Senator Cost?
Yeah, I was there, and fortunately, the testimony from those present was all positive. I don't know why the House went 4-4, but the chairman decided that he didn't like it and voted against it, and so that's where that ended. There was no testimony against it. In fact, the current way that it's written was with the amendment proposed by the Wyoming Press Association's Mr. Angel. And he felt that was a friendly amendment to make it much tighter. I agreed with that. And after the Senate Judiciary, we had agreed to amend it to that so that it was much better. The goal with this was not to try to create an out or whatever. It's just to make sure, especially in the school districts, that there's protection of our kids when you're talking about the special doors that allow people in and out, when you're talking about procedures for the way you're going to secure kids and protect kids, when you're talking about your internet and the different provisions for it. So it's only when it really does propose a threat to the kids or the property that you need to seriously look at it. I appreciate what Mr. Merrill is saying. I would ask that maybe we could consider that in a separate bill if somebody wants to, because I really feel this bill is extremely important, especially for our schools, but it has valid implications for our cities and all, with all the things that are going on now, to be able to use it in the same manner. Our schools, to be perfectly honest with you, there is a executive permission, provided you bring your attorney or whomever to the meeting with you. And it's the attorney, the district attorney, or the chief of police or one of his deputies. So that really limits the ability to be able to talk about that if you didn't get them. Of course, the attorneys are on the pay scale, so therefore you're going to end up being charged for it, which is more expense. So just the idea that they can talk about this and make those decisions with their tech people, I think, is really important. That's about all I can tell you about it.
Well, it looks like Senator Cost has kind of explained the bill draft proposed here. Is there any further public comment on the Open Meetings Act or proposals from Mr. Merrill? All right, seeing none, let's go to Senator Cost's bill and have him kind of present that officially, and we'll deal with that bill.
I would ask that we move it forward.
Okay, so we're going to working draft 70, which is public meetings, executive sessions for security planning. Senator Cost, why don't you explain the bill and the purpose? You kind of did already, but more officially, and Mr. Fuller is here to help as well.
Thank you, Madam, and I can use all the help that anybody wants to offer. The bill basically inserts one extra amendment or addition to the executive session, and that's number 7 on page 2 at the top of the page, lines 2 through 4. All it does is says to consider, discuss, and conduct safety and security planning that, if disclosed, would pose a threat to the safety of life or property. And then down below on line 12, it just renumbers I through XII rather than I through XI. And that's really all there is to the bill, unless Mr. Fuller would like to add something to it. It's very simple, straightforward, and just adds that one extra addition.
All right, questions for Mr. Fuller or Senator Cost, Representative Jennings?
Yeah, at the very end of that, I guess I'm okay with everything in here, but I'm just have a little bit of heartburn there where it says pose a threat to the safety of property or of life, I understand, but or property. That be misconstrued, and I mean, it looks to me like you could discuss about anything having to do with property. Is there a way to tighten that down just a little bit? I don't know. There's enough lawyers here. Maybe one of them can make a suggestion, or maybe it's not even a deal. But it seems like that if you just put a threat to property, it could be somebody spray painting your jungle gym or something, you know, and maybe there's something. Maybe there's nothing there, but it just kind of gives me a little bit of heartburn.
Yeah, Senator Cost?
Yes, thank you. And in response to Representative Jennings, if somebody could come up with something that would maybe tighten that up. But the biggest concern, obviously, there's been bombings of schools, bombings of different buildings. And so that is really the direction that this is intended to protect from.
All right, helpful. Representative Stiff?
Madam Chairman, I second Senator Cost's motion if that has not already been done, and would say with respect to the current language, I think threat to property is a legitimate concern. And so I think it would be appropriate to have an executive session to discuss security planning if it were related to preventing vandalism, for example. I think that would be a legitimate discussion to have an executive session. So on and for the bill.
All right, so there's a motion and there's a second. Further discussion on the bill or questions? Question being called on the bill. This will be a roll call vote on the bill.
Madam Chairwoman, this is a roll call vote on 21 LSO 70 version 3. Senator Ansami Dahl.
Point of order, Madam Chairman. Point of order.
Yes, Representative Gray.
I don't recall us drafting this bill. So, I mean, don't we need to request LSO bring a bill draft first and then we proceed with it in October? I mean, I don't recall that. And so I understand Senator Cost is bringing his idea forward, but I don't think we approved the motion to make it a formal bill draft.
I think you're right, Representative Gray. So I think this is Senator Cost's motion for us to review. Good catch there. So the motion is to direct LSO to turn this into a joint judiciary committee bill. I assume Representative Stiff that you second that still, and we are to vote. All right. As a result of that, we'll vote on the actual bill draft in our third meeting to go forward. So this will just be a raise of your hands. So all those in favor of directing LSO to do a bill draft, making it a joint judiciary bill, raise your hands. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13. How lovely is that? It's unanimous. All those opposed? Seeing none. All right. That motion has carried. Senator Cost, all that worry for nothing. Okay, committee, back on kind of finishing out public meetings. Any discussion, any conversation about Mr. Merrill's request? 5:20. All right, seeing none, let's move to our last agenda item of the day. The Wyoming Supreme Court opinions, those bill drafts that we had come out of those. Mr. Fuller, are you prepared to proceed?
Chairman Ethercott, members of the committee, I'll start with 21 LSO 49, draft point 4, Board of Coroner Standards Investigation Authority. As part of the review of Supreme Court opinions in May, the committee looked at a case concerning the authority of the Board of Coroner Standards to investigate complaints of coroner misconduct during inquests or coroner's cases. In that case, a majority of the Supreme Court had held that current statute does not grant the board that authority. This bill draft grants that authority essentially. On page 2, line 2, this just inserts a paragraph that says that within the board's duties, that one of their duties is to investigate complaints of misconduct by coroners and deputy coroners during coroners' cases, including complaints that a coroner didn't comply with certification standards or with standards that are promulgated by rule for investigating coroners' cases. And the staff comment just highlights the other provisions that are implicated by adding this paragraph, where there are requirements to promulgate rules for reviewing complaints and standards for investigating coroners' cases. The change on page 3, lines 5 through 7, just requires the board to contact the county attorney or the attorney general to initiate an action to remove a coroner whose certification has been recommended by the board for revocation as a result of any investigation or review. This language is more of a conforming change to track with the new language that was added on page 2. With that, I'm happy to answer questions.
Thank you, Mr. Fuller. Representative Washut.
Thank you, Madam Chair. Does the Coroner's Board want this responsibility?
Mr. Fuller?
Chairman Ethercott, Representative Washut, we have not heard from the Board of Coroner Standards. If I recall correctly, I am not sure if there were even appointments by the current governor to that board. With that in mind, I drafted the bill based on the committee direction after reviewing that case, and that's about as I can give you.
Mr. Fuller, can you remind us the facts of that case for why they determined that the board didn't have an authority to investigate a particular coroner?
Yeah, Chairman Ethercott, just in brief, there was a party, a person became incapacitated and I believe eventually passed away. That led to an inquest that led to a finding against the property owner who tried to challenge that coroner's, the way the coroner handled the investigation, and the board itself had said, we lack the authority to investigate those provisions. That case wound itself to the Supreme Court, where the court held that the majority held that it didn't have the authority. A justice who dissented, I believe, focused on the language that authorizes the board to promulgate standards for investigating coroners' cases. And the implication was based on that, if they could promulgate standards to investigate the cases, then within that authority is the ability to investigate complaints of misconduct or not following those standards. So that is where the court split came. This language just plainly decides that, addresses that issue and gives them that authority.
Representative Stith.
I apologize, no comment.
Representative Gray.
Thank you, Madam Chairman. So, Mr. Fuller, my recollection on that case was that the property owner wanted some kind of finding, reversing the decision of the coroner or whatever. And does this wording, it says they can investigate, but okay, so they issue a report on their investigation. They can't reverse the coroner's ruling or whatever. And I just want to, is my reading of this correct?
Yeah, Chairman Ethercott, Representative Gray, there were actually that property owner brought two separate cases. The first, which is a bit more distant in the past, so I will try to recall it. I'm not sure why the Supreme Court reversed. I'm not sure if they found that I don't remember if they lacked jurisdiction or what. But the property owner did try to challenge, I believe, the findings themselves. This case that was presented, where there was a dissent concerning, the interpretation of a statute of the Board of Coroner Standards statute, dealt only with the question of whether the board could investigate complaints of misconduct. What the end result would be for that particular appellant in terms of their specific situation, I'm not sure how investigation of misconduct would have resulted in reversing the findings of that coroner's case. Here all we're dealing, I'm just dealing with is if there is a complaint of misconduct, the board can investigate it.
Yeah, further discussion from the committee? All right, we don't have any public comment. So committee, what's your pleasure? Senator Anselmi Dalton?
Move the bill.
Moved by Anselmi Dalton. Is there a second? Seconded by Pelkey. Discussion on the bill. Representative Washut?
I would move that we table until we hear from the coroner's board on whether they have the capacity or the interest in even having this responsibility.
Senator Anselmi Dalton?
I don't think it really needs to be tabled. I think the best way to get people to the table is to not table, because otherwise they just drift along and they won't appear. And so I think even though I understand what you're saying and it's good to get people involved, they have a chance to get involved at it. It's not a complicated bill. I would urge against tabling. Thank you.
Further discussion? All those in favor of this is a roll call vote.
Do we have a second on that?
Yep, Representative Pelkey seconded. Discussion occurred. Roll call vote, Mary Beth.
Madam Chairman, point of order.
Representative Gray.
Just to clarify, we're voting on the motion to table is the roll call, correct? Not.
Oh, no, I forgot. Representative Washut, did you move to table?
Yes.
Was there a second?
Second, yes.
Seconded by Representative Smith. Okay, all those in favor of tabling the bill, raise your hands. 3 vote in favor of tabling the bill. All those opposed, raise your hands. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11. That motion has failed. Back on Senator Anselmi Dalton's motion to adopt the bill draft as a joint Judiciary Committee bill. Roll call vote, Mary Beth.
Senator Anselmi Dalton.
Aye.
Senator Boner.
Aye.
Senator Koss.
Aye.
Senator Von Slater.
Excuse.
Representative Burlingame.
Aye.
Representative Gray.
Aye.
Representative Jennings.
Aye.
Representative Pelkey.
Aye.
Representative Pannell.
Aye.
Representative Salazar.
Aye.
Representative Stith.
Aye.
Representative Washut.
No.
Co-Chairman Cookbride.
Aye.
Co-Chairman Nethercott.
Aye.
That passes.
All right. So now we're on to our final item on the agenda, which is LSO Working Draft 58, Judicial Review of Agency Actions, Permissible Venues. Mr. Fuller, do you want to walk us through this one?
Chairman Nethercott, members of the committee, the committee reviewed at the May meeting a Supreme Court case that held that a person who was challenging the denial of workers' compensation benefits couldn't challenge the agency's denial in the district court where the injury occurred. This was a person who lived in rural Albany County, I believe was injured on the job up in Campbell County, and filed the petition for review of the agency's action in Campbell County. The Supreme Court held that was an impermissible court to file the petition for review and dismissed it over the dissent, I believe, of 2 of the members of the court. So what this bill draft does is just authorizes that the district court where the injury occurred as a permissible venue to seek review of agency actions. And so 21 LSO 58, this is draft point 4, page 2, line 8. We're just adding language that says that judicial review can be sought by a person aggrieved by an agency decision or action or inaction in the district court for the county in which the injury or harm for which relief is sought occurred. Page 3, line 1, this just provides applicability that the act applies to petitions for judicial review filed on or after the effective date of this act, which would be July 1st, 2021. With that, I'm happy to answer questions.
Thank you, Mr. Fuller. Any questions of Mr. Fuller? Yeah, I'm pretty excited about these two bills that are pretty easy for us to manage. Representative Pannell?
Move the bill.
Is there a second? Seconded by Anselmi Dalton. All right, discussion on the bill? All right, roll call vote, Mary Beth.
Question.
Senator Anselmi Dalton.
Aye.
Senator Boner.
Aye.
Senator Koss.
Aye.
Senator Von Slater.
Excused.
Representative Burlingame.
Aye.
Representative Gray.
Aye.
Representative Jennings.
Aye.
Representative Pelkey.
Aye.
Representative Paul Now.
Aye.
Representative Salazar.
Aye.
Representative Stith.
Aye.
Representative Washut.
Aye.
Co-Chairman Cookbride.
Aye.
Co-Chairman Nethercott.
Aye.
That passes.
Thank you, Mary Beth. So this bill, although subtle, to me is a really, really big bill because the individual, and I don't know anybody involved, but I mean, that whose case this was not entitled to any kind of relief as a result of their attorney following what would have been pretty typical civil rules of procedure of where to file a case where an injury occurred in your hometown court. They were barred from doing that, and therefore they were then barred from receiving justice for something kind of that silly. And we heard, local control and all that, but this was kind of an absurd result in our law, and I'm glad to see it fixed. So I think in the future, some good attorney representing some good client won't make that mistake, and that client won't be without justice. So I think we've just solved some problems with that bill. All right, we did some good work the last 2 days. Representative Burlingame.
Thank you, Madam Chairwoman. I just wanted to bring it to the committee's attention, even though I can't seem to figure out how to share the picture here, that the judiciary in the state of Wyoming was very ably represented by Representative Washut and myself. 2/3 of the Wyoming team at the governor's gun shoot up in Cody came from Judiciary. Not bad.
Nice work.
We may have come in behind South Dakota and Colorado, but we beat Utah, and that's what counts.
It is what counts. Way to go. Congratulations on beating Utah. Glad to hear it. One outstanding item that we may want to address, this was discussed yesterday. I just thought bringing it up. There was that technical issue associated with the consolidated theft crimes bill of that removal of the word or that has created kind of this conundrum when it relates to jury instructions. Is the committee interested in directing LSO to have that corrected and bring back the or? Representative Stith?
Madam Chairman, I would make a motion to authorize and direct LSO to prepare a bill draft to fix the anomaly in the consolidated theft crime statute.
That looks like it's seconded by Representative. All right, moved by Representative Stith, seconded by Representative Pelkey. Discussion on that? All right, all those in favor, raise your hands. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13. Looks like that's unanimous as well, but all opposed or any opposed? Seeing none, that motion has passed. All right, any other items from the committee before we get kind of a recap of what we've done the last 2 days? Representative Gray?
Sorry, inadvertently raised hand. Thank you.
All right. Well, we'll move to Mr. Fuller to give him a minute and give us a recap of what damage we did today.
Do you, Chairman Ellicott, do you just want today's actions?
We heard it yesterday, which was helpful, but if you want to go and remind us of those as well, so we get a sense of what our next meeting looks like here.
Okay, will do. This will take a minute. So yesterday, the committee failed to sponsor or act on the zero tolerance bill draft, the DUI zero tolerance. It voted to sponsor the youthful offender bill draft. The Ethics and Disclosure Act bill draft was moved to the next meeting. The committee voted to sponsor the interference with public contracting bill draft. The committee requested a bill draft for the next meeting for public contracting issues based on the working group's report from Representative Stith. A bill draft to put in LSO form the rewrite of Title 25, Chapter 10. The committee voted to sponsor 21 LSO 81, the DUI amendments, and then requested a bill based on County Attorney Weissman's language for the salary for county attorneys. Today, the committee voted to sponsor 21 LSO 82, the electronic filing bill draft. The committee voted to sponsor 108, which was the public health emergencies immunity bill draft that was prepared for the Judiciary Committee. The committee took no action on 47, which was the district court's budget repeal. It tabled the bill draft on the fiscal administrative control for the district courts, tabled the bill draft on the judicial workload, failed the bill draft on the municipal services recovery action. The committee requested a bill draft for the next meeting regarding the definition of personnel file for the Public Records Act, with a working group of Representatives Gray, Pelkey, and Washut appointed to that. A bill draft to clarify that the agency from which a record originates is the custodian for purposes of releasing that public record. The committee voted to turn 21 LSO 70, Senator Koss's bill draft, into a committee bill for consideration at the next meeting. The committee voted to sponsor 21 LSO 48, which was the coroner's standards bill draft, as well as 59, which was the, 58, which was the agency review of judicial actions, and then a bill draft to add or to the elements of theft in 63402, I believe is the section number. And just one more note, we have on our calendar the next meeting for October 26th and 27th. Halloween's on a Saturday this year, so not sure if the committee wants to rock on the weekend or not.
Maybe that was last year. It was Halloween. I don't know. It was
last year.
Okay. Good, you get free Halloweens. Representative Pelkey?
Madam Chairman, since you're probably in charge at least one of those days, do we have to show up in costume?
You already do. No, yeah, no, don't do that. Hopefully we'll be live. It'll be in Cheyenne, hopefully. I mean, I would love to see everybody do this live. We'll see how it goes. I'm hopeful. All right, any final comments from the committee? I think we did some incredible work, and we are the #1 committee. We have worked our tails off, and we have done good stuff. So, Representative Gray?
Yeah, Madam Chairman, can you clarify, because I've gotten different words about what Management Council has told the committee chairs. Do you have to formally request some waiver to do an in-person meeting, or where are we at on, is it totally your discretion, or because I don't know, and I've heard different things.
They did give us guidance. I don't really know what that is. Mr. Fuller?
Yeah, Chairman Ellicott, Representative Gray, my understanding based on the actions of the last Management Council is that the current policy of the Management Council when the public health emergency began is still in effect, which states that meetings are online. To deviate from that policy would require the committee, specifically the chairman, to request basically a variance from Management Council of holding a meeting, whether it's some sort of hybrid format or a full in-person meeting.
Senator Anselmi Dalton.
Thank you, Madam Chair. Just as I'm on Management Council, we do vote on it, Representative Gray, and they say something like, oh, we'd like to meet in Cheyenne, but another part is that to have the technical requirements. LSL staff is generally excluded from having to attend those meetings. And so the chairperson has to say that they're going to make sure everything's up and functional. For example, when Chairman Driscoll wanted it to be in Thermopolis, he said he'd take care of all the technical aspects up there. And just so you're kind of aware of how it does occur. And but the other people don't have to attend either. It's voluntary who attends.
Co-Chairman Kirkbride.
A couple of things as we wrap up. I thought the committee worked really hard. These were long days. So thank you to all of you who did that. Thank you, Madam Co-Chairman, for your deft handling of the committee today. And I would like to comment that those 3 or 4 bills that we tabled, we didn't send them into outer space. We would have to have a motion to take them off the table, and then they would be considered just like normal bills at the next meeting if that's approved. And so give some thought to those, and then some we needed a little more information before we were ready to deal with them. But that's where I see that heading with those 3 or 4 or 5 bills that we tabled this session.
Thank you, Co-Chairman. Words of wisdom, appreciate it. All right, with that, with everyone, this meeting is adjourned. We'll see you soon, and have a great weekend. Thank you.
Thanks. Good job, Chairman.